Yeah, bro, it's 3 only.
Court officer, am I audible? Sir, you are on mute. Am I audible, sir?
Madam, audible.
Thank you.
Echo ಆಗ್ತಾ ಇದೆ ಸರ್. ಅವರು ಅವ್ರ ಕಡೆ
Madam, I think you have
Madam?
two system, one computer, two speakers, right?
No, sir. Only one speaker is there.
Your voice is being echoed here. Whether you
21.
on both mobile and laptop, something like that?
No, sir. No, sir. Only laptop is on. Right now, it is also echoing.
not now, sir. Not now.
It's
Not now, madam. It's working, madam.
Okay, sir. Okay.
This
kind indulgence, my lord. My lord, your lordship kindly earlier on 1/10/2024, regarding black pepper matter, my lord. My lords has passed an interim order directing the authorities to release the cargo within 2 days from the date of the receipt of the order. My lord, in spite of the surety bond and bank guarantee, they have accepted. Surety bond, they have raised objections, my lord. We have given as per the pro forma of the my lord respondent, we have submitted by through Mercantile Bank. Mercantile Bank has given the surety of the, but in spite of the repeated request and emails, my lord, they have not considered, they have not released the cargo, my lord. Therefore, I request and kindly have it on Wednesday, my lord, because otherwise, my lord, it is.
When is the, when is the date otherwise?
My lord, 14, today, my lord, matter has to come for today, because of bench is not combination of the bench is not there, my lord. That is why it is not posted.
Just one minute.
Wednesday, my lord, I request, my lord. My lord, your lordship.
To do one thing, just to come after lunch.
Please,
We'll see the convenience of Justice Rajesh.
please, grateful.
Come back after lunch.
2:30, I will come. Grateful.
Who
Shetty,
MSC is for withdrawal, my lord, tomorrow. Already filed.
want to withdraw?
Withdraw, please.
On the other side, Mr. Shetty,
No, in that, nobody is,
no notice was gone.
no, my-
You are the
because
appellant.
acquittal order has been challenged by
You are the
the,
appellant.
I am for the appellant. There is no
So this would come to
impediment.
us. Yes,
Lordships kindly, 2 commercial appeals are settled to
just take that.
My lord, this is a MFA of 2020. Okay.
No, are these matters settled?
settlement.
So you want to, who is the appellant? You are the appellant?
I am the,
You want to withdraw those?
we have to pay them the amount before the
There is
court.
a settlement and.
Yes, yes, ma'am.
Is it on record settlement?
It is all already on record.
On this,
Not before this court, before the Madras High Court. There's a connected matter there.
then you may have to inform the other side.
I have already informed
Just say about when do you want it to be listed?
tomorrow, ma'am,
What is the position tomorrow?
or day after tomorrow.
We'll have it tomorrow.
Much of,
Just inform the council also.
I have already,
Again for tomorrow.
yes.
Yes, ma'am.
My lord, this is MFA of 2022. It is a disposed matter. Award amount has to be deposited by the appellants. So this honorable court has also confirmed the award amount. So kindly, we have already filed an application for deposit of the amount by appellants. So,
Award given, challenged, rejected,
yes, my lord.
then how this would lie now here?
My lord, they have to deposit the amount as per Supreme Court, 100% of the amount as per Supreme Court precedents. So they have deposited only 60% of the amount. Rest of the 40% they have to
Pursuant
deposit.
to which directions? Whose directions?
My lord, I can't recall the name of the citation, but there is a direction. No, my lord, Supreme Court.
But where is the order of the Supreme Court?
No, the precedent I'm talking about, not the, this matter has not reached the Supreme Court. It is pending, it is disposed.
To know. There are no proceedings pending here now.
No, my lord.
Then why this application?
For my lord, appellants have to deposit the amount as per award and also confirmed by this honorable court. So we have filed application for that reason.
Now we have doubt whether such an application shall be maintainable.
My lord, we had filed application prior to this as well, after the case was disposed.
Just show us the mentioning slip. Is here. Ma'am, the proceedings are not pending. We don't know. How can you file such an application for deposit? Are there any proceedings pending?
No, my lord.
Then, is there any execution pending?
Execution is pending, my lord.
We'll work it out. We'll just think over it.
My lord, appellants had filed a recall application. The court dismissed, subject to payment of so and
For
so.
respondents,
We are for respondents.
but they have not got the appeal revived.
No, my lord.
There are no proceedings. Why are you filing this up? You are for the respondents.
Yes, my lord.
Why are you filing this application? We don't understand. Just think over it. Just think over it when there are no proceedings. Where will we ask for the deposit when there are no proceedings? Think over it. Okay?
Sure, ma'am.
Your Lordship, serial number.
Take the slip back. Think over it. Yes.
Well, this is a commercial application of 22, wherein we, the appellants, have been directed to, we've been directed to deposit the amounts of the award, my lords, including interest. We have filed IA number 2 to withdraw the bank guarantee furnished by us. The matter can be listed on the 16th. That's day after tomorrow.
You have deposited the amount.
Lords, we had deposited a bank guarantee, which was not the full amount.
Furnish the bank guarantee
Please,
in favor of the claimant or whosoever the claimant.
please, my lords.
Now, what do you want on this?
My lords, we want to argue on IA number 2, which is for withdrawal of the guarantee, and then we will be in compliance with the order dated 5/7.
You are for the appellant
Please, my lords,
who want to withdraw the bank guarantee.
please,
But the proceeding starts still pending, this appeal is still pending.
please, my lords, pending.
What is the date of hearing?
The next date of hearing, I don't think a date was fixed, which is why we wanted to be fixed on the 16th.
It says 16th.
Wait,
Yes, Mr.
wait.
We have filed a memo, my lord, for withdrawal of a commercial appeal. Suit itself is coming up today. That also we are withdrawing. In fact, Mr. Dhyan Chinnappa was on the other side. He was here, my lord. He was called to the other court. And I request your lordships to have it, my lord, at 2:30. We are withdrawing the vote.
Mr. Chinnappa is appearing for the other
Yes,
side.
yes. Commercial appeal, my lord, suit is coming up before the court today. That also we will be withdrawing. There's a settlement.
Okay, but can't wait for tomorrow.
The thing is, my lord, that there are two suits. Both, my lord, we are withdrawing. Therefore, my lord, yeah. Please, please.
Not today, even possible. Not possible.
Please.
Just inform, Mr.
Yes,
Hussain, the briefing
I'll-
counsel must inform Mr.
Yes, yes, please, please. We have, in fact, he was here. Then I'll inform him myself, and they'll also.
My lord, this is the commercial appeal of the year 2023. My lord, we have filed a IA for vacating stay. My lord, may I request my lords to have it any date in the next week, my lord?
Is it an award? Is the award challenge to the
My lord, arbitral award has been challenged in the commercial
before
appeal.
dismiss?
Please, my lord,
Is it 37?
37.
Just take it. When do you want? Just
Any date next week.
see any convenient date.
23.
Well, grateful. Lord, serial number 30, my lord, the final hearing list. I'm appearing for the respondent, my lord.
You said 30.
30, my lord.
Yes.
It is a state appeal, my lord. In this particular case, my lord, we filed an application before the Supreme Court to transfer these cases to Supreme Court itself. The notice,
The issue is pending there.
yes, my lord. Because this is not,
What is the order passed? For transfer.
yes,
What is the, this shows? We will defer it.
Please,
Okay. All these matters, all in.
All
you have
four cases.
filed in all the matters.
all the cases. Lordship may see the numbers there.
Then the counsel appearing for the, you are for the respondent?
Respondent.
Respondents in this appeals states that the respondents have filed application for transfer of these appeals to the Honorable Supreme Court as identical issue is pending consideration there. And notice has been issued on those transfer petitions. He states that these matters be deferred to await the outcome of the transfer petitions. At his, in Kadana, the learned counsel appearing for the respondent, the appellants, non-applicants.
Please,
The appellants.
appellate in 30.2 and 30.3.
You are for all the appellants, no?
My lords, I appear for the appellant the state in 30.2 and 30.3. That
Which
is-
point two?
I appear for the respondent number 2, Union of India in both the matters.
Very well. In Kadana, the counsels appearing for the, I hope all are represented.
My lords,
Yes.
The opposite party. I just say that appellants have no objection with regard to the appeals being adjourned in view of the aforesaid position. To stop accordingly, we notified us in December.
Your Lordship, serial number 29.
Madam, 1 minute, madam. 10th of December,
any date.
10th of
In December?
10th of
Much
December.
obliged.
Yes, ma'am.
Your Lordship, serial number 29.
Yes.
Presenting for the respondent side. Your Lordship, because of some personal inconvenience, the advocate is not able to attend the matter today. Can it be posted after 2 or 3 weeks, Your Lordship?
I appear for appellants, my lords. Very well, my lords.
Just show the file. They will take it.
There's 229 and 29.1, my lords.
Pardon?
29 and 29.1.
Yeah. Just say this. You'll file your written submissions.
I will file my written submission.
Have it been admitted?
Yes, my lords.
The counsel for the, ma'am, you appear for whom? Respondents?
Respondents, Your Lordship.
The counsel for the respondents in this matter seeks an adjournment on the ground that the arguing counsel is in personal difficulty. The request is not opposed. Re-notify on. Liberty shall be with the counsel for the parties to file the written submissions along with the judgments they want to rely on. Within 3 weeks, 4 weeks, just say 4 weeks.
Your Lordship, serial number,
Yes, ma'am.
Your Lordship.
serial number 22. I'm appearing for the
Yeah,
rest.
yes. Yes. Give the date.
20th November,
Yes, ma'am, tell us.
serial number 22, appearing for the respondent in this matter, Your Lordship. It says appeal by the GST department seeking for a short accommodation. It may be had anytime this week or next week. I've informed the appellant's counsel as well.
Now, why this adjournment?
Senior is not available today, Your Lordship, and he's anytime.
You appear for whom?
My lords, I am the additional government advocate for the state, my lord. I have no difficulty.
You are not in this?
My lords, I'm led here by the additional advocate general. I have no objection to the adjournment. On the ground that the arguing counsel is not well, I have no difficulty.
But tell us one thing on this. But technically, what are they? You are for the respondent, na?
Yes, Your Lordship.
The original petitioner
Yes.
before the learner
Yes,
syndicate.
Your Lordship.
This is your appeal.
The-
My appeal.
So otherwise, what is the way out of this issue? Would you give credit to them for that so that they can also repay it to the vendor?
My lord, matter may have to be gone into, my lords, and
The procedure is that the credit note gets created by the vendor. The point that the respondent herein had urged before this learned single judge was the credit note cannot be issued because the entire sale itself is not completed. On that grounds, the writ petition came to be allowed and the learned.
That's right, but very well. Let's see, adjournment is sought by the counsel for the respondent on the ground that the senior arguing counsel is unwell.
Yes, Your Lordship.
Is he unwell?
Yes, Your Lordship.
Unwell. Adjourn to.
Sir, 11th of November.
Call the list.
Serial number 1.
Appellant pays for 2 weeks time, finally to compel the office objections.
6 weeks are granted to clear the office objections.
Much obliged.
Re-notify.
212.
In this case as well, my lord.
Serial number,
Then
Serial number 2 also, my lord.
serial number 2,
same order.
212.
2.
Serial number 3, Shri Joseph Anthony.
Lordship, I'm filing memo for withdrawal.
Want to withdraw this?
Yes, madam.
Then the counsel for the appellant has filed a memo for withdrawing the appeal. The memo reads as under, in view of the reiteration of the prayer as made in the memo for withdrawal, comma, the appeal is dismissed as withdrawal.
Most obliged.
Serial number 4,
I appear on behalf of the appellant, my lord. My lord, in this matter, we have taken steps 3 times, and I have also taken steps today for the 4th time. In compliance with with an order of this this honorable court, we've also taken steps through online mode, that is through email, but there seems to be no representation from their side. So I request this honorable court to allow us to take summons through substituted services, my lord.
There's one thing,
My lord,
this order
my lord,
impugned
my lord.
is the complete amount has been directed to be refunded.
My lord, if I may invite my lord's attention, there was a common order that was passed by the adjudicating officer on 14/2/2019, my lord.
We are in item 4.
Item 4, my lord.
That's right.
Rera appeal
Rera, yes.
23456, my lord. My lord, there was a common order that was passed by the adjudicating officer, Rera, on 14/2/2019, by which all the complaints were allowed, my lord. Further,
What was the complaint for?
the complaint was with respect to, if I may invite my lord's attention to page 12, my lord. Para 2, my lord. If I may read, my lord. The respondent number 1 filed a complaint bearing number so-and-so before the adjudicating officer Rera under section 31 of the Real Estate Regulation and Development Act 2016, alleging that the respondent number 1 and their entire family had paid a sum of rupees 3,94,42,500 for purchase of 40 flats in an apartment complex known as Unica Emporis belonging to appellant company. It is further alleged in the complaint that the appellant had failed to hand over the physical possession of flats by the end of 2015, and hence the complaint was filed before the respondent number 2, Rera. This was the reason the complaint was filed.
So what has been directed by the authority?
The authority has allowed all the complaints, and it has also directed us to refund the money. And it has also, if I may invite my lord's attention to page 2, my lord. On 30/7/2019, the Secretary of Rera, by its order, directed the Deputy Commissioner Bangalore to initiate appropriate proceedings under the Karnataka Land Revenue Act and rules.
It's all right. We are, see, your appeal
Please.
has been dismissed. You did not deposit the complete amount, pre-deposit.
There is one aspect that I would like to highlight there, my lord. We challenged all the complaints, my lord. 8 of those orders were set aside, and it was remanded back to the adjudicating officer due to the lack of jurisdiction that they had in order to pass such an order. However,
Jurisdiction means?
my lord, the adjudicating officer, if I may invite my lord's attention to the
But this appeal,
Please, my lords.
the tribunal has been rejected because you did not deposit the complete amount.
In the 5 appeals that I've filed before the High Court, yes, my lord. The rest of the 8 appeals that the orders which were passed by the appellate authority by remanding the matter back to Rera, I had deposited, my lord.
The complete amount.
Please, my lords.
Very well. Now, insofar as these are concerned,
Please, my lords.
this is a case where the refund, whatever amount was given or deposited by the complainant, that has been directed to be refunded with interest.
But the matter has been remanded back to the adjudicating officer Rera in order to for fresh consideration, my lord.
Right, but how will your appeal be considered unless and until you make the complete pre-deposit?
If I may, my lord, my respectful submission is that my senior will make arguments for that. I request this honorable court for permission to take summons to substituted service.
Are you saying in this batch of 12 complaints,
Please, my
some
lord.
have been remanded back and
Please,
some not?
please. That is precisely what my submission is.
Where is the order of remand? Is it here on record?
I'm afraid it is not on record, my lord, but I'll produce it on the next date of hearing, my lord.
Just say that at the request in the, who was to be served on this?
My lord, respond number 1
One.
in all the 5 appeals, my lord.
See, the
including-
law is very clear. Even in New Tech, it has been clearly held. Where the complete amount has been deposited, ultimately, it's not a case of compensation. It's a case of refund.
Please, my lords.
Refund, you have to deposit complete.
Please, my lords.
That-
My lord, but my respectful submission is that, my lord, let me be allowed to take notice to substituted services, and my senior will come and put forth his arguments, my lord.
It is
It's my
based-
respectful submission, my lord.
Prima facie, I don't think there is nothing in this appeal. Prima facie, subject to what you want or your senior wants to say. This is our view because New Tech is very clear.
Please.
Even New Tech is clear. That's the reason why this appeal should be pending. That's it.
It's my,
File an application then for substituted.
I will do the needful, my lord.
Where is the office noting then? They have refused. The report says unclaimed, return to sender. Unclaimed is as good as a refusal.
Please, my lords.
If it is a refusal, why should you have a substituted service? He is rejected, he is refused it.
But
Where is this report? This report?
my lord, my respectful submission would be that, my lord.
Is the order there after that?
If I may, my lord.
What happened to those remand appeals?
That is pending consideration.
They're still pending.
Pending consideration. My lord, my respectful submission is that the requirement under Order 5 Rule 17, when there is refusal to accept service, those criteria have not been met. So I would request this honorable court that I be allowed to take out notice through substituted service under 5 Rule 20, my lord.
The counsel for the appellant seeks and states that he shall take steps to effect the notice on the respondent number 1 through substituted service by filing a separate application. At his request, re-notify him.
611.
I'm so grateful, my lord.
Just say this next.
Serial number 5, Sanmati.
It's coming up for orders, my lords, but other side, my lords, is coming before the court. I'll serve them, my lords, the papers.
I may be permitted to accept notice on behalf of the
Ma'am,
respondent.
you appear for the respondent?
Yes,
here?
ma'am.
Hmm,
You're undertaking to file local.
Yes.
Though respondent is unserved, so and so appears for the respondent states that she shall accept notice for the respondent. She also states that wakalat shall be filed on behalf of the respondent within 1 week from today. List the matter for admission on. You have the copy of the appeal?
Not yet, my lord.
I'll serve a
Yes,
copy.
If a copy of the appeal be given to the counsel appearing for the respondent within 1 week.
2810. Serial number 6.
Yes, Mr. Shetty, what has to be done in all these things?
6 and 7, my lord, it has become infructuous, my lord, in view of the order of discharge has been confirmed by the Supreme Court. So
6
far
and
as,
7 have become infructuous.
please, my lord, I am filing memo. Because same party, my lord.
What about the others?
That's my lord, I want, because I have paid the court fee now, I will have to satisfy the office, my lord, I will comply with all other, otherwise, my lord, everything is over. Short time may be granted, I will comply in all the cases, my lord.
Mr. Shetty, Leonard, just this is in 6 and 7.
6 and 7.
Now, Mr. Shetty submits
What else?
that
what else?
in view of the order passed by the Supreme Court in SLP civil number,
Criminal, my
SLP criminal
criminal.
number 4258 of 2021. There is only one. Acha, this Parvati Kullur and another includes this gentleman
No,
also?
Parvati Kallur, my lord, I have already withdrawn it. And this Avinash, my lord, Avinash, in both the cases, my lord, as a president as well as single capacity, he is representing.
So this is 6 is, okay, acha. So we'll record this order only.
Please, my lord, in that he is a party, my lord.
Oh.
Another is he is,
That's what we wanted.
yes,
to know.
I have verified.
States that the present appeals have become infructuous and be dismissed as having become infructuous. The memo for withdrawal filed by Mr. Shetty reads as under. The same encloses the order passed by the Supreme Court on 16/8/22. Full stop. Taking the memo for withdrawal on record, comma, the MSA 81 of 2018 is dismissed as infructuous, same would be MSA 82 of 2018. But is there any separate memo in the other matter?
I just fire only single memo, sorry.
In this, it is single memo.
Because in both, my lord, he is a common respondent.
Dismissed as withdrawn, dismissed as infructuous.
Infructuous. Because in view of that Vijay Madanlal case, my lord, all MSs are going now. In connected matter, my lord, they have already filed.
Just show us those connected matters.
Serial number 8.
8 to 12, my lord. I pray for a short time, my lord, I will come. In that, against the acquittal order, revision appeal is also filed, my lord, by the state.
Against acquittal order.
Please. Before Kalburgi bench. I verified that.
I'm sure the last order sheet.
Hello.
These are the office objections, Mr. Shetty,
I have already complied, my lord.
in all the matters.
Please, my lord, if there is any, my lord, I will comply it and
Mr.
clear everything. The court fee has been paid, my lord, in all the matter.
Mr. Shetty states that though he has removed the office objections, comma, he shall verify the same. Shall verify the same before making his
Liquid leave, Commissioner, leave.
To stop at his request, re-notify on. Just say after 4 weeks. Just check up, Mr. Shetty.
Please, my lord, I will get it ready.
11, sir.
This will be from 8 to 12.
8 to 12, my lord. Please.
Serial number 13, Shri Sanmati. 13.
Kindly pass over my notes. So Mr. Sanmati is on his
Heavy
To be done in
permits.
this.
matters that be matter for admission, my lords. I don't have the files, my lords, but Sanmati is on his legs.
Is this transfer pricing issue pending?
My lords, some more transfer pricing issues pending, my lord. Yes, my lords. A coordinate bench is also hearing the matter.
Huh.
All the remand matters, my lords, those are pending before coordinate bench, my lords.
So now this 13 onwards,
Some are transfer pricing, my lords, some are not transfer pricing, my lords.
some on, which are not, which are transfer pricing?
My lords, I'm not sure about 13, 14, my lords. But
No, 13 it appears to be.
yes, I don't have other files.
Will you just check out?
I'll just check up, my lords.
We'll just pass over.
Yes, my lords. 21 is a
21 also.
21, my lord, I appear for the respondent.
But the question of law, my lord, has been admitted for the earlier year.
In which
Please.
matter?
In 21.
No, we were just only asking because this 13 onwards. it
Even
is-
that is also transfer pricing, but transfer pricing also, my lord, many of the issues, question of laws have been admitted.
Okay,
So, my lord, in the previous bench, my lord, wherever the identical question of laws have been admitted, they are being admitted. In admission state.
No,
Only
no.
final hearing matters, my lord, they are being deferred. Because coordinate bench, my lord, is seized with the,
which are those matters which have not been admitted?
all the matters. All these matters.
all these matters. my lord.
Matters coming for admission.
Most of the matters, my lord, in transfer pricing, my lord, identical question of laws have been admitted.
You have the
So-
last order where it has been admitted. Do you have the last order?
Please, we do.
Just show us that, please. Or we'll just pass over, just get those orders, pass over. So what you are saying is, those matters which are not admitted have been admitted. Those matters which were for final hearing have been deferred in view of the pendency before the coordinate bench. That's what you are saying. We'll just pass over. 22, up to 21.
22 adjourn.
Till 21, no, till 21, we are passing it over. Just get that over. Which one?
15 is not a transfer pricing matter, and
15.
19 is not a transfer pricing matter. 15 is a matter covered. 19 is 263.
19 is not, my lords. 19 is not.
Transfer pricing.
Item 19 was not a transfer pricing matter. It is a 263 order.
What about 15?
15 is not a transfer pricing.
Your Lordship, 15, my lord, I have to Your Lordship, I have to file memo for framing the additional substantial question of law, my lord. Your Lordship, may kindly have it next week. There is also one more connected matter, my lord.
Just 1 minute. Yes.
Okay, someone. 284 or 23. 284 or 23. 15, may I submit, my lord? My lords have got the file.
Your Lordship, 15, there is one more connected matter, my lord, of the same assessee. It may be clubbed along with that, my lord.
When is the date there, anything?
There is no date, my lord.
So then why don't you move a memo in that if the issue is identical?
Yes, my lord. Yes, my lord, I will file
In fact,
memo.
2 other years, the same issue was there. This honorable court has dismissed the revenues appeals. And the matter went up to the Supreme Court. Supreme Court also did not interfere.
But the other pending matter where it is pending, pending before this honorable, the same issue is involved, not. And moreover, I want to file a memo seeking for framing the additional substantial question of law, my lord. Therefore, I am seeking for 1 week time.
No, but would that, this additional question of law
That is not, that is,
covered by the old judgment?
No,
eh,
that's not a different
that is
issue.
different issue, but that is also covered against me.
That's also covered.
But I have to formally, I have to seek permission of this honorable court to,
That the issue comes and ultimately fate according to you.
yes, my lord. I have to bring it on record.
This will be in 15.
Serial number 15. my lord.
15 months.
The learner counsel for the appellant seeks an adjournment on the ground that he intends to file a memo for framing an additional issue.
Yes, my lord.
Stuff at his request. Re-note, when do you want?
Next week, Monday, my lord,
After 2 weeks.
along with the ITA number.
But you must file a memo for
I will file the memo in counter.
that in the other one.
Yes.
Got it.
28.
Your lordship, may
Can
kindly
it be
direct the
next?
office registry to club this matter along with that, not. Your lordship can, in this matter, my lord.
My lords may direct this matter to be clubbed with the other ITA.
No, but there is no date there.
There's no date there, but your lordships can here say that this matter be taken up with that and fix a date in this, so that will automatically come.
We thought that you file a memo, then we'll ask it to become on record. File a memo. You give it in the morning, during the course of the day, get a
Right.
memo,
Please, my lord. I
so
will,
that it's there on record. Okay?
please, my lord.
2810.
Grateful.
Your lordship, serial number 13, my lord, there is one more connected matter, my lord. In that case also, I will file memo, my lord. In that connected matter, this honorable court has issued the notice, my lord, arising out of the same common order. Common order of the tribunal, we filed 2 appeals, one already notice has been issued,
But no date there.
no date.
We'll adjourn this also. Otherwise, this is also transfer pricing it.
Yes, my lord, transfer pricing.
And that coordinate bench which is hearing it also have a bearing here.
Yes, my lord, it will have a bearing, my lord.
According to us, my lord, it should not, because transfer pricing, as your lordships know, depends on facts of each case. The department has been taking time saying that the coordinate bench has heard one matter. Now, I'll just give a brief background of what happened to transfer pricing matters here on an earlier occasion. On an earlier occasion, in the case of soft brands, a coordinate bench of this honorable court took a view that transfer pricing matters, the issues that are involved in transfer pricing matters are primarily questions of fact. Unless the tribunal's order is attacked on the ground of perversity, the questions of law do not arise before this honorable court under 268. Now that matter, soft brands, following soft brands, many other transfer pricing matters were dismissed. Appeals of the revenue were dismissed and some appeals of the SCs were also dismissed. Rightly or wrongly, without going into the facts of each case. Ideally, facts of each case should have been gone into and seen whether there was perversity in the tribunal's order.
Perversity become questions of law.
Correct, if there is perversity. If perversity has to be demonstrated first from the tribunal's order. So following soft brands, many matters were disposed by this honorable court. The entire batch of matters went to the Honorable Supreme Court. Honorable Supreme Court again reiterated the same thing, because ultimately what is required to be looked into by this honorable court is a substantial question of law. And substantial question of law in a case of question of fact can arise only if there is perversity in the tribunal's order. That's what the Honorable Supreme Court has said and sent all the matters back. Now, one of the matters was taken up by a coordinate bench and heard and reserved for judgment.
It is not.
But really, in each case, it has to be seen, because facts of each case will necessarily be different. It can't be the same. It cannot have any bearing. It's not, each case has to be looked at independently.
Coordinate bench, my lord, we are given to understand, my lord, they'll lay down the parameters, my lord. That's what the earlier bench said. They lay down the parameters. That's why we are waiting.
All other high courts have been taking up transfer pricing matters and looking at whether there's a question of law or not and disposing of matters, of course.
Very well, we'll just
We were told, my lord, a detailed judgment will be rendered.
No, you're right. We were just only seeing in which are the matters, all the matters are transfer pricing, then we defer it. or accept this, what you are saying is, let there be an admission, okay? And then thereafter defer it.
My lord, for example, my lord, serial number 21, my lord, the tribunal followed its own earlier order in this case of the same SSC. That has been, my lord, the earlier year, the revenue preferred an appeal before this honorable court, and the question of law has been admitted. So this matter may be admitted, my lord, then
Which other matters need to be admitted?
21, my lord, which is
Yes,
21, I
show us-
appear for the
show us
respondent.
that. Where is the order? It would be an identical question of law.
identical.
Who appears for the respondent in this?
I appear for the respondent, my lord, on BC.
Hmm.
As the learned counsel for the revenue also says, my lord, the previous, it's on the similar lines that the tribunal's order has also been passed. The questions of law have been admitted in identical appeals also. And in fact, my lord, on the previous date
My lord,
of
next-
hearing also, the
My lord,
this
question
honorable
number
court
one,
had
my lord.
admitted the-
Yes.
Not all, only one. Question number one, substantial question of law, one.
at page
Admitted, my lord, on 22/7/2022.
That's right. 22/7.
22, that's on the second page.
So this is the only
Only,
only
Please.
issue is only one.
only one in the,
That's right. Ma'am, we will admit this.
Yes.
Okay. We will also, there is a similar matter. Just say this. The learner counsel for the appellant revenue states that this is a transfer pricing matter and a similar appeal being ITA 249 of 2022. 249, huh?
my lord, ITA number 250.
Pardon?
250 of 22.
Is it 250 or 249?
250, my lord, case number.
Okay, 250 of 22. And 249 of 22. 249 also. The
Please.
250 refers to 249.
Please.
Be clear?
Please.
Have been
Please.
admitted. So the submission is taken on record. The appeal is admitted to consider the following substantial question of
law.
Only one. Whether on the facts and circumstances of the case and in law, the tribunal was right in directing TPO to calculate RPT ratio on an aggregate basis, taking the ratio of RPT income plus RPT expenses by sales across the board for all the comparable companies without acknowledging the fact that the transfer pricing officer, just say bracket TPO, has calculated RPT ratio for all the comparables, applying the formula as RPT income by total sales and RPT expenses by total expenses. That's right?
Please.
The list this appeal along with ITA 249/22 and 250/22. That's right. Is there any date in these matters?
No.
No, my lord. It's been
No
done.
dates.
Just give a date. Then only thing is, if they are transfer pricing, then we will have it on one day. Just give Monday, man.
My lord, all income tax matters, ma'am. All
We have
all tax
income-
matters.
Yeah, on Monday we'll have. I hope it is convenient to everyone.
Earlier also Monday.
That's right, that's what. Just give it on Monday. Next, man. 22 is adjourned now. Which one? Others pass over, another council.
19 is not a transfer pricing.
We just passed over, let the council come so that we can have it.
19, council is here.
So 19, what is 19 is not the same?
19 is not the same.
Not
19 is
transfer
a
pricing.
It's a two
revisional order, my lords. It's a 263 revisional order. Now, my lords, what has happened is, for assessment year 15-16, my lords, a return of income. For assessment year 15-16, return of income, my lords, was filed on 30th of November 2015, my lords. Now, my lords, a draft assessment order was passed. And finally, my lords, the DRP directions also was passed, my lords. The final assessment order, my lords, was passed on 25th of October 2019. Now, my lords, this was subject to revision, my lords, by the Principal Commissioner under Section 263. My lords, he has disallowed, my lords, everything that the AO has done, my lords, and passed an order to that effect, saying, my lords, please look at, my lords, Annexure E. Page 113, my lords. This is the impugned order, my lords, before the tribunal. Annexure E, my lords. If I may read just read para 2, my lords. It has been observed that the amount of rupees so-and-so towards commission on sales debited by associate profit and loss account without TDS was not disallowed under section 40AIA in assessment order. Failure to do so has resulted in short computation of income of rupees so-and-so.
Which page? Sorry, which page?
113, my lords. 113, para 2. As to what was the order of revision, my lords, by the Principal Commissioner. If I may, my lords.
Yes.
It has been observed that the amount of rupees so-and-so towards commission on sales debited by assessee to profit and loss accounts without TDS was not disallowed under section 40A in the assessment order. Failure to do so has resulted in short computation of income of rupees so-and-so with a consequent tax effect of rupees so-and-so, my lords. In view of these facts, the assessment order was considered to be erroneous and prejudicial to the interest of the revenue in terms of 263. It was therefore proposed to pass an order under 263 in this case. A show cause notice was issued on 19/3/2022, giving an assessee an opportunity to filing the submission. In response, the assessee has filed a reply dated so-and-so. Now, my lords, the submission of the assessee has been carefully considered. The assessee claimed that the issue was considered by AO during assessment proceedings is not acceptable, considering the facts discussed above, particularly as the assessee has not filed necessary evidence along with the above reply to substantiate these claims. Considering the facts, it is clear that TDS was required to be done on rupees so-and-so, debited by the assessee to profit and loss accounts towards commission on sales. As the assessee did not do the TDS on this amount, the AO should have disallowed this amount under section 40AIA. The AO has not made this disallowance, even though a similar disallowance has been made for assessment year 13-14 and assessment year 14-15. The AO erroneously has not made the disallowance in assessment order. Not making disallowance is contrary to the law. So on this basis, my lords, the Principal Commissioner reverses the findings of the AO, my lords. My lords, please look at the para 8 and 10, my lords, for a minute.
Para 8 and 10 of the same.
Yes, my lords. As discussed above, the TDS was required to be done on rupees so-and-so debited by the assessee to the profit and loss account towards commission on sales. As assessee did not do the TDS on this amount, the AO should have disallowed this amount under section 40AIA. The AO has not made this disallowance, even though similar disallowance has been made for AY 13-14 and AY 14-15. The AO has erroneously not made the disallowance in the assessment order. Not making the disallowance is untenable in law, and failure to do so has resulted in shortage of computation of income of rupees 10 crore 90 lakhs 23,000 with a consequent tax effect of 5 crore 74 lakhs 38,000. This has resulted in loss of revenue. Considering this fact, the assessment order is erroneous and the prejudicial to interest of revenue in terms of 263. And the conclusion was para 10. In view of the above discussion, the assessment order under 143.3 is erroneous and prejudicial to the interest of the revenue in terms of 263. The assessment order is accordingly set aside for this purpose, and AO was directed under 263 to make a fresh assessment accordance with law. After considering the above, the AO shall examine the issues discussed above and conduct necessary inquiries in accordance with the law and stability guidelines. The AO shall consider disallowance under 40AIA on the transaction discussed above. He shall give.
He has remanded the matter.
Yes, my lords. Now, this was impugned, my lords, before the tribunal by the assessee. Please look at, my lords, Annexure A.
They have impugned it.
They have impugned, my lords. And the tribunal has ruled in their favor, hence revenue is in appeal.
They say that there is no right, there is no power to remand.
No. They say, my lords, that the assessment order considered all the factual aspects, and then the AO, in his considered wisdom, has come to a conclusion for disallowance, my lords. That is the finding of the tribunal.
But otherwise you are fine with this order? of
Yes, my
remand?
lords, I'm fine with the tribunal. And that is the only substantial question of law, my lords, actually. Annexed to A, my lords, page 13 as to how the tribunal considers it.
Let's see his finding.
Yes, my
Class 6 onwards.
Para 6, my lords, para 7 is what is relevant. Para 6, my lords. We have heard the rival submission and peruse the material on record. For the relevant AY, the assessment was selected for scrutiny during the course of assessment proceedings. It was questioned the impugned transactions of the expenditure amounting to 36.34 crores. The relevant provision of the notice issued on 142.1 and dated so-and-so directing the assessee to explain the commission expenditure reads as follows. Commission expenditure to the extent of 36.3 crores has been incurred during the AY under consideration. Please explain in brief the nature of expenditure and also if TDS has been applied. Number of the response, my lords. In response to the above question, assessee filed reply by letter dated so-and-so. The assessee furnished the sample agreements and contested that it is not liable to deduct tax at source under 194H. The reply submitted by assessee by submission letter dated reads as follows. Now, my lords, the tribunal, my lords, consulted the entire submissions of the assessee, my lords, from page 6.
Page 6.
Sorry, my lords, para 18, page 18, my lords. My apologies. 18, 19, my lords, 20 and 21 is the reply. Para 8, my lords. Not satisfied with the above reply, AOS issued another note show cause notice on 12/8/19, providing an opportunity to assessee to justify non-deduction of tax at source on the above combination payments. The relevant part of AO show cause notice dated so and so reads as follows. Now, as for the second show cause, my lords, they again reply. That runs from, my lords, page 22 onwards till page 25, my lords. Now, para 10, my lords, is the finding. From above show cause notice is issued by the AO and the reply submitted by the assessee. It is clear that the AO has examined the impugned transaction in detail during the course of assessment proceedings for the year under consideration. The assessee during the course of assessment proceedings has also admittedly placed on record the distribution agreement on the debit notes. From this, the only inference that can be drawn is that AO has taken conscious decision in not making the disallowance under 40A of the Act. Therefore, the PCIT reasoning that AO has not examined the issue in accordance with law and has not conducted necessary inquiries is incorrect. Since AO has taken a plausible view, the said assessment order cannot be subjected to revision under 263 of the Act. In this context, we rely upon judgment of the Honorable Supreme Court in Max India. So based on that particular finding, my lords, is the reason why the impugned order has been set aside by the tribunal, my lords. And please look at, my lords, para 12 for a minute, my lords. Moreover, from the report AO submitted the learned DR, it is clear that the subsequent assessment 16, 17, 17, 18, 18, 19, the commission expenditure was not disallowed in the final assessment order completed for those assessment years. It is pertinent to mention for the above said assessment years, the AO has called in question the availability of commission payments during the course of assessment proceedings. An assessee has filed similar reply, and it was filed in the impugned assessment year. However, no disallowance for the expenditure was made under 40A of the Act. It's pertinent to mention that AY 2018-19, the final assessment order was passed subsequent to the impugned order passed under 263 of the Act. For aforesaid reasons, judicial pronouncements said we quashed the impugned division orders. What the tribunal does not consider is, my lords, for the previous years that has been taken into consideration by the learned PCIT, that is for the year 13, 14, 14, 15. Disallowance was made, and that's the only reason, my lords, why we're in appeal, my lords.
But tell us one thing, if ultimately the original order gets revived, ultimately the matter will go to the...
No, now it does not stand revived, my lords.
Now it would not.
But the AO, my lords, based on PCIT finding, will have to redo the entire calculation, my lords. But now, because of the tribunal order, it cannot do so because the revisionary provision is set aside, my lords.
So what follows?
What follows is, my lords, that we are challenging this order, saying that the impugned order of the PCIT will have to stand, and and the AO will have to do fresh proceedings according to, my lords, according to the impugned order.
Even after this order also, is there anything remains for a fresh consideration?
Yes, my lords, it does, my lords. Because the PCIT, my lords, overruled the AO's order. The assessment order has been overruled. Now he'll have to do a fresh according to the findings of the PCIT. That is the only substantial question of law, my lords.
Will admit, this has been admitted? No.
No, my lords.
We'll admit this.
I mean, the tribunal says jurisdiction under 263 has not been rightly invoked. That's what, because 263, my lord, can only be invoked if the order is erroneous or prejudicial to the interest of the revenue.
But
now, the only error.
That finding is there.
That finding is there, but the finding is that the AO has, the PCIT says, the commissioner says that the AO's order is erroneous because he has not examined this issue. which is incorrect, which the tribunal says is incorrect. Tribunal says AO has issued multiple notices on this issue, examined this issue, come to a conclusion that this is not in the nature of commission, but in the nature of discount. Where is the applicability of 194H? My lord, when there is no error, invocation of jurisdiction, how can he invoke jurisdiction under rules?
Now effectively after this order by the ITAT, now we have to examine it.
Whether 263 has been rightly invoked. The question that has been raised also, my lord, the question that arises before your lordship's for your lordship's consideration is whether 263 has been rightly invoked in the facts of this case.
Now, because I think now it would be more, not even academic, sending it back to the initial authority.
Because moreover, subsequent years, that's what the tribunal also notes. Subsequent year also, revenue has accepted that these are not in the nature of commission. It is discount. 194H is not applicable, and therefore 40A1 disallowance doesn't apply. If subsequent years department itself has accepted it, where is the question of?
But for the previous years, 13, 14, 14, 15. We're dealing with 15.
For the later years.
Later years,
Previous years also, the AO did the invocation of 263 is on the ground that earlier 2 years this has been done. That we filed appeals before the tribunal. Tribunal set aside those orders and said, first look into whether these the payments are in the nature of commission and discount, and sent the matters back. Thereafter, the department has not taken any action at all. So as on today,
there is no decision by the department.
No decision by the department after remand by the tribunal.
The later this thing has come.
Later this thing has come, accepted it. So the only inference is that the department has accepted this issue.
that is a dichotomy, my lords.
Pardon?
That is a dichotomy, my lords. We'll have to examine, my lords, as to why for subsequent years.
Is based on your say not, at least assessing these 2013, 14, 14, 15, the earlier years. Just say this, admit the following substantial question of law arises for consideration. Just say that having heard the counsel for the parties, whether on facts and circumstances of the case, the tribunal was justified in quashing the revisionary order. That's right?
Yes, my lords.
When the assessment order passed was erroneous and prejudicial to the interest of the revenue. And when it is not a case where AO has taken one of legally plausible views and the disallowance was erroneously not made. Good stuff. Okay, list the appeal for hearing on. There is no pending issues elsewhere in any other appeal?
No, my lords.
Just give counsel for the parties to file their written submissions along with the judgments through e-filing.
Yes, my lords. E-filing.
Now, I think in this jurisdiction, everything is e-filing.
Yes, my lords. Yes, my lords. We'll have to do an e-filing first.
Appeals, only the appeals. The tax matters, my lords.
One should file everything.
Yes, yes.
Just give it after 4 or 6 weeks.
Would your lordships fix a date or?
You're giving a date.
Very well.
Sir, 25/11.
Next.
Great.
There are 21 and 22 adjourned. 23, Sri Balram, R. Rao, 23.
What is this?
Lordship, this is a appeal against a single judge's order, wherein we are challenging the order which is passed by the single judge. The issue which arises for consideration before your lordships is the notice and issued under section 148AB of the Act. The assessing officer has given me less than 7 days statutory time limit as specified under the
Now
Act.
you have remedies available now. Now
Yes, your
much
lordship.
water has flown thereafter.
I agree, your lordship. But your lordship, it is a purely a legal issue, your lordship.
Will not set the clock back. Not like this. What will happen, all the subsequent proceedings which you have? You would be within your rights, if permissible in law, to take all these pleas which are available. See, even thereafter, what notices have been now issued? What are the present proceedings pending?
The appeal is pending, your lordship.
That's right, one. And there is a further notice issued to you under 274,
And that is with regard to the penalty proceedings, Your Lordship.
right? So it's everything arises from all these proceedings only.
I agree, Your Lordship.
The learned judge is right.
Your Lordship,
Can't put the clock back.
no, Your Lordship, a week's time may be granted, Your Lordship. I will take instructions and
We'll just pass over, take instructions. See, it has to be that way. It has to be that way. That's an initial, the foundation was that, but even the building has come up. Now, if the foundation goes, everything, we are not saying so. That's for you to take a call. Maybe if it's permissible in law, you will urge it.
it is permissible, Your Lordship.
Yeah, take instruction, will pass over, pass over. Permissible, that's more reason than you must. We'll tell you the reason also. Possibly you'll have a remedy also thereafter. You're getting the point?
Your Lordship, only one prayer, Your Lordship. I will undertake to withdraw, Your Lordship, but a direction to dispose of the appeal within a
There
time.
is already a direction by the learned single judge on that count.
I agree, Your Lordship, but
There is
no
a
time limit,
non-compliance, remedy is elsewhere.
no time limit is fixed, Your Lordship.
See, the difficulty is, the work, they have earlier appeals pending. They say, why one appeal? We say nothing because the learned single judge has observed. Take instructions, pass over.
No, Your Lordship, I will undertake.
Right? Oh,
Withdraw.
I'll just say this, after some submissions, learned counsel for the appellant seeks to withdraw the appeal. Instead, the petition is dismissed as withdrawn. The appeal is dismissed as withdrawn. Thank you.
Much obliged.
Next.
Serial number 24, Sridhar Murthy.
My lord, in this matter, we retired from this matter. I filed a memo also.
Now, this is a very old appeal, I suppose.
Yes, ma'am.
Tell us one thing.
Ma'am.
Does anything survive in this?
Well, so far as the post-GST, this is pre-VAT also.
That's right.
I'm not aware of what assessments, if any, he has opened, and if he thinks he'll succeed over here,
When
then
did
he's
he,
entitled to any refund.
when did he file the petition challenging these provisions?
Well, in 2004, ma'am. It was
That is pre-GST era.
pre-VAT. It was just after the VAT. What happened was that there was a amendment to the Sales Tax Act. Sales Tax Act said imported silk imported from other countries can be taxed at 4%. He challenges it. In 2009, the learned single judge rules against it. Goes up to the division bench, has it restored on the ground that he was not given an opportunity to be heard. The second round, learned single judge again rules against it. Short question that arises, my lord, is whether 301 and 304 impose any restriction on me levying a tax of 4% on
We
imported
just
silk.
want to know if this is academic today in the present scenario.
My lord.
Why should you pursue this appeal? That's the reason we want to know. You want to take retirement, huh?
We
You
already
want to
filed
take discharge.
Yes, ma'am.
Trying to see the last order, my lord. Unfortunately, I don't come in the way of this court, my lord's friend, but it's my duty to place on record the last order. My lords would kindly see the last order dated 3/6/2024. I'm not coming in the way, my lords, your lordship.
Which order, what is the date?
3/6/2024, my lords, 3rd of June 2024.
Oh, your request was rejected.
My lords.
Your request was rejected.
I don't come in the way, but it's my duty to point this out so that there's no incongruence.
You've seen the last order. You were the counsel then. And it's rejected by another fresh application. And now this order is, we will not allow this application. We can't relook in the order, relook an order which is already states that you will not be allowed.
Well, that's all the.
Now we want to know what remains in this appeal.
My lords, on my submission is, we handed over all the files to my client.
But today, today,
my lords.
today, those provisions are not in vogue. How would, let's assume for a moment, you succeed in the appeal. What follows? See, we can't, unless we can't be, there cannot be any decision in vacuum, you know, it's just only thing is academically, it's very good. Because ultimately we are dealing with constitutional provisions. But there is no follow-up, there is no consequence. Why should we go into it?
The Supreme Court now, my lord, repeatedly holds that when 301 says trade and commerce is free, it is not free from taxation. Only such taxes that debilitate the ability of a person to carry on trade and commerce are subject to 301.
You take instructions, we'll just pass over.
My lords, in submission. We don't have any files. And we handed over all the files to my client. He said he is engaging another advocate.
We will not allow in view of this order of 3624. We will not allow that. See, 3624 is rightly, a similar application was rejected.
36, so I don't have any.
Just see this order.
Have you seen that order? Have you seen that order? 36.
Just read this order.
Yes.
So in view of this order, you don't press this application, okay?
Yes, my lords.
So
I'll take
that's now we will proceed. You are the counsel.
Well.
We want to know from you what remains or what need to be adjudicated in the present scenario.
I'll take instruction.
We'll just pass over, take instruction.
Yes.
Pass over.
25, serial number 25. So given
Yes,
For the respondent.
you are for respondent.
Issue, my lord, in this writ.
Yes, you are for the appellant.
I for the blank, my lords.
Yes, tell us
Yes,
what is there.
my lord, say, Leonard Single just directed us to, my lord, the refund the, my lord, the amount which was, my lord, voluntarily paid during the course of the investigation.
Issue is actually pending before.
No, I'm sorry, my mistake.
Ah,
Okay.
right. 25, my lords. This is
Yeah.
the,
No, I got confused with the
Yes.
other matter. Yes,
yes. My lord, now the issue is this.
just give us the file.
My lord, issue is this, my lord. This is an investigation, my lord, initiated by the officers of the Directorate of Revenue Intelligence. There is an investigation wing called a Directorate of Revenue Intelligence attached to the Customs Department. Last May. Now the controversy is,
What happened? The Supreme Court had decided it.
no, Supreme Court has not yet decided, my lord, this issue. It is reserved. It may be, my lord, by another 2 weeks.
That issue will cover this also.
My lord, that issue will cover the locus of this appellant to initiate investigation and issue show cause notice. If it is held in my favor, my lord, I am entitled to argue the matter on merits of the. If it is held against me, my lord, my appeal is liable to be dismissed.
So we'll defer it. It's reserved now.
It is reserved before the Honorable Appellate Court.
Just say this. On the last date of hearing,
Yes, my lord, same.
that is on 15/7/2024. This court had noted the fact that noted the submission made by the counsel appearing for the appellant.
Yes.
That's right, it's strongly said. Appellant, that one of the questions arising in this appeal is being debated before the Supreme Court.
Yes.
In a review matter. And the court adjourned the matter by 8 weeks. The learned counsel for the parties states that the Supreme Court has reserved the matter.
Yes.
Or reserved the matter for judgment and request that the matter be deferred to await the judgment, that their request re-notify on. It's only one of the issues. There are other issues also.
My lord, if this issue is decided, my lord, other issues need not be gone into because this goes to the root of the matter. Our jurisdiction itself is, my lord, questionable.
Okay.
3 weeks, my lord.
You petition, no? Review petition number 420.
After 3 weeks, your lordship.
We'll have it after 4 weeks, please. 4 weeks.
212, sir. 212. Twenty-six. 26.
Yes, Mr. Rajgopal, who is opposing? Who is the other side?
Sure.
You ready?
I am ready, Manoj.
We'll hear it. We'll just pass over.
Very well.
27.
We'll hear this matter. Next.
27. Shri Deshpande Amit Anand.
Appearing for the respondent, my lords.
Yes.
There is a change in the counsel for the appellant in these matters, my lord.
Change in the counsel for?
The appellant, my lords,
Appellant.
some appeals. Twenty-seven and 27.1, lords.
Now you will appear.
I will appear, my lord. I undertake to appear in both the matters.
Now, this issue, just tell us one thing.
I don't have papers, my lord. I just, my lord.
You don't have?
Yes, I'll get, my lord, next week.
Yes,
lord.
this so-and-so appears for the appellant and states that henceforth he shall represent the appellant in these appeals and request for an adjournment. Full stop. At his request, re-notify her.
Next week.
411.
Please,
Obliged, my lords. Both the matters, no?
please, 27 and 27.1.
Yes.
Number 28. Number 28.
I appear for the respondent, Your Lordship, in this matter.
My lord, there are two appeals. Two appeals. One is filed by the
The
revenue.
cross appeals, no?
Cross appeals. Same order.
What is the challenge by you?
My lord, my challenge is,
Yeah, your challenge
Lord,
is
his grievance is that, my lord, interest is not awarded on the refund. There is a delay refund. There is a delay in granting refund. For that delay, the tribunal should have, my lord, observed that they are entitled for a interest for the delayed period. That's his grievance. Now mine is, my lord, the tribunal should not have, my lord, passed an order granting and refund, my lord. That's my appeal.
their appeal will depend upon your appeal.
Yes.
Lord, the preliminary objection is that there is a circular, Lord, the refund amount is approximately 40 lakhs.
But
There is a,
just 1 minute. What is this this judgment?
Yes.
Ellen Diesel India Private Limited. Is it on record?
It's not on record.
not on record, Your Lordship.
I don't think, my lord, any judgments have been placed on record of this honorable court. So
Not yet, Your Lordship.
Oh, yeah, right. There is a reference made there.
yes.
But this issue is on 1% is conclusive now.
Conclusive, Your Lordship. The Honorable Supreme Court in the case of
What
Wipro.
follows then, if it is conclusive, then what remains? What is your best argument then?
No, my lord, my best argument is this. Without, my lord, an modification of an assessment, it is, they are already assessed. Now, my lord, he did not seek, my lord, an amendment of an assessment order or a modification of the assessment order. Now, he directly, my lord, makes an application for a refund. Now, the Supreme Court says, you cannot make an application for a refund without getting the, my lord, the assessment order modified, because the refund sanctioning authority is different from the assessing adjudicating authority.
But that would stand, that attain finality.
My lord, which one?
The assessment order.
Assessment order attained finality. So without disturbing the assessment order, the refund sanctioning authority cannot sit on the assessment order and, my lord, give a refund, dehorse the assessment order. Or this is the, my lord, the ground. This is the only ground, my lord, which I'm before my lord, sir.
But was this ground urged?
No, Your Lordship.
I'm not aware of.
No, Your Lordship.
But susstat, there is no reference.
At least from the impugned order, it doesn't appear.
It doesn't appear. It doesn't appear.
Your Lordship, the Honorable Supreme Court held that the levy itself is unconstitutional.
Then why didn't you challenge your assessment order?
Lordship, when the levy itself was unconstitutional because the
You are right. You are right. But let's see. But you have heard his argument.
I'm grateful, Your Lordship. There is a decision of the Honorable Supreme Court.
Finality.
Lordship, why at the time of assessment, the
Two
matter.
judgments of the Supreme Court are there, my lord. I'll place it on record, my lord. I'll get this.
I'm grateful, Your
This
Lordship.
is, I just want to see, this is Delhi High Court.
Yes.
This, we just wanted to see, we will see it, Ellen Diesels.
I'll place it on record, Your Lordship.
My lord, the claim of the, my lord, the respondent is on merits, whether the, my lord, the levy.
You are ready to argue?
Lord, before that, my lord, my learned friend raised an preliminary objection to the maintainability of my appeal itself on the ground of monetary limit. Monetary limit. My lord, my humble submission is that.
What are the otherwise the instructions of the, this is basically customs.
My lord, this customs also, my lord, the same, my lord. Now at that time, my lord, the instruction says that, my lord, it is 1 crore and above. Then only, my lord, it's maintainable before the High Court.
What is your take on that?
My lord, there is an exception carved out of this, my lord, the circular, which says that, my lord, the refund issues which are legal and recurring in nature are saved from this, my lord.
Your question of law on interpretation.
This is the, my lord. So my case falls within this, my lord. That's whether the.
Now suppose the amount is less than 1 crore or 10 crores, whatever is the.
1 crore.
Can we leave the question of law open?
Question of law can be kept open to be decided in, my lord, appropriate cases, my lord. These courts have held that without answering the questions of law, the matter has been remitted back to the.
But it is a larger issue.
Since the tribunal has not considered this issue, particularly, my lord, in view of the, my lord, judgment of the 2 judgments of the Honorable Apex Court, my lord can remit the matter back to the tribunal. That's one.
But you don't disagree if he was to seek the modification of the assessment order or otherwise, he would have succeeded.
That depends, my lord, again.
Why depends? Suppose he was to seek a modification going by the law which is now been crystallized. You also agree crystallized. He would have succeeded to the extent.
Perhaps, my lord, to that extent, my lord, he would have succeeded.
Okay. Now, which are the judgments you want to rely upon?
Only 2 judgments, my lord, which the authority also rely on, my lord. I get the copies, my lord, in list. I just give, my lord, I need some time to place it on record. With the memo.
You want to put it or we'll pass over?
Lordship, can you pass over?
Okay, pass over.
Obliged.
Next, ma'am.
My colleague who is on record is traveling, madam.
Which number?
Serial number 20.
26.
Yeah. Maybe if I have it on next week.
Hear it. Let's start from there. Okay. Yeah, let's see that.
Passed over matters.
Next,
Serial number 13.
Your Lordship, in assessee, same case, in ITA number
Now-
729 of 23.
which one we are taking?
13, sir, one.
Your Lordship, there.
13.
Serial 13, may I be permitted to file my wakalat on behalf of the respondent?
You will be appearing
Yes.
for the respondent?
Yes.
And what about 14? This is also transfer pricing?
Your Lordship, 14 is also transfer pricing, my lord, wherein the connected matter in assessee's own case, it has been admitted, my lord.
In which one? 14?
14.
Admitted. Where is that order?
Yes, my lord.
We'll frame an identical
Yes, my lord.
and we'll have it on the same day.
Yes.
This transfer pricing.
In assessee's own case, my lord, in ITA number
Now, where are the question of law questions?
Your Lordship, in this case, the questions of law are at page number, my lord. Page number 8, my lord. It's
All
not,
would arise for consideration.
Your Lordship, page number 7, the questions which requires to be admitted, my lord, question number 2, my lord. Question number 2, 3, 6, 2, 3, 6. And 11, my lord.
Oh, sorry. 2, 3,
6 and 11.
2, 3, 6 and 11.
Yes, my lord.
4 questions.
Yes.
Just say this. Admit the following substantial questions of law arises for consideration. No, we have been informed that on an identical issue,
In assessee's own case.
in the case of the respondent SSC, the appeal has been admitted. Full stop. In this regard, the learned counsel for the appellant has drawn our attention to order passed in ITA 222 of 2022. 222 of 2022. Orders, just say that orders passed in ITA numbers. Full stop. The noting the said submission and hearing the counsel for the parties. The following questions of law, substantial questions of law arises for consideration in this appeal. Full stop. This would be page 8, serial number 2, 3, 6. That's right, page 8.
Page 8 and
Just have a look also.
yes.
8 and 9, huh?
8 and 9.
Yeah, we don't want 2, 3, 6 and 11.
Yes, ma'am.
Okay. Establish the appeal for hearing on the same date, ma'am, which we have given a transfer pricing. The counsel for the parties to file their written submissions.
Your
along
Lordship
with
may
the
kindly
judgment.
defer this matter, just admit it not, because giving of further dates, my lord, in fresh matters need not be necessary. Because, Your Lordship, the Supreme Court has remanded almost about 130 cases. That is first batch of cases, not transfer.
Okay, what are you saying? We should not admit it?
Your Lordship may kindly admit it, but kindly give any further date, my lord. Let the remanded matters be disposed of first.
Which are those?
Which are those matters, my lord?
But you have said it's pending for judgment.
Your Lordship, it has been heard at length, my lord, and for concluding part, my lord, it is
Oh, it's not reserved for judgment?
not yet resolved.
No, what?
May I clarify a word? Not all the remanded matters have been. One of the matters of the remanded matters has been heard by a coordinate bench. That's what I was submitting.
What has been represented is possibly the court is considering to
Pick
lay
some
down-
parameters
lay
where a
down
question of,
parameters.
yes, in
That be so, possibly that may.
correct, but that is only in one matter, not the all 130 matters which have been remanded.
But one matter, if it would be parameters which may cover all situations, possibly.
Yes, my lord. That has been taken as a leading matter.
My humble submission is very difficult to do something like that. I'm sure your lordships have.
No, maybe you're right. I be at least surely talking about me personally and my learned brother also. Though we did this direct taxes, but very limitedly. So surely we'll be looking forward for a good assistance for us to also look into it.
Yes.
Surely you may be right. On a facts, definitely much would depend upon facts of each case. But in any case, we'll have it after 4 weeks on that day. We will see what is the position there, then we will defer it further. Or if you want a longer.
No,
we
what
can
my
take a
learned
long-
friend is submitting is that these are newer appeals. There are a lot of other transfer pricing appeals. He wants the appeals to be posted chronologically than
Because
fixing
these
a
are all
date in
new
new
matters,
matters,
Lord.
because there are many old matters pending from 15, 16 year, filed in say 15,
So
16.
giving of
That's
date
what
for
my
fresh
learned
matter
friend
is not.
We don't know what is the process generally. Old appeals need to be first heard.
Yes, my lord.
Usually final hearing, my lord, is chronologically taken up.
Okay, very well. We'll take it that way. So we don't give any date then.
Please, my lord. Yes, my lord, because the old matters has to be heard first.
Unless it's a matter which can be disposed of.
If it is both the
it's
sides
covered
agreeable
matter or
for
a short
disposal,
matter, my lord, usually
short matter,
Then we'll do
Matters are-
something in the earlier one, which we have given date, we will not give a date.
please
We will just only say
admit and post for hearing.
admit and post for hearing.
Yes, ma'am.
Then for all of you, once that decided, you want to seek the decision in this, then you will file your memos, everything.
Yes, ma'am.
Don't give the date in that matter. Which was the date which we had given? But I think the council was here.
411.
Seal number 21, my lord.
Was the council there for the respondents?
Yes, ma'am.
Yeah, she was there, but in her absence, possibly we can't say so. We will just retain insofar as that is concerned.
Yes, ma'am.
We will not vary that all. In this, just list for hearing. Okay,
Yes, ma'am.
this takes care of 14.
Yes, ma'am.
Now what about 13?
13, my lord, your lordship, I maybe take, but they have entered appearance, my lord. It may be urgent. I will serve the copy, my lord.
Very well. So and so appears for the respondent, states that she shall file her wakalatnama within 1 week.
Yes, my lord.
So let a copy of the appeal paper book be given to the council within 1 week from today.
Yes, ma'am.
List the appeal for hearing,
Yes, ma'am.
just in due course. So. Then, list the, what did he say?
16.
15 memo.
Shall we say in due course?
No, this is an admission matter, my lord. Item 13 is admission. Item 13, which your lordships are adjourning now, is to be formally admitted.
Then we'll give it.
So let the papers be served. My lords will see the
date
paper.
there. We'll give it, shall we
Yes,
give a
it
date?
can be taken up on 28th or something, 2 weeks later,
Date.
28th October.
2810.
Great.
We'll hear it formally admitted, then we'll put it for hearing.
Please, ma'am.
16.
Your lordship may kindly 15, my lord, your lordship, there is one more connected matter, 284 of 2023.
15 is already adjourned.
15, sir.
15.
15 days.
Already adjourned agidiyalla.
What happened?
it is not-
You have to file the
28.
16, call ಮಾಡಿರೋದು.
16.
Now what has to be done in 16?
16, my lord, although it's a transfer pricing matter, my submission is that the very issue has been decided by a coordinate bench of this honorable court, straightforward covered. The issue is, my lord, what happened is 92 BA. There was a provision to tax. 92 BA, my lord, is basically defines what are specified domestic transactions. So clause 1 of that provision included transactions between related entities who are domestic if they have interstate transactions of expenditure, which are otherwise scrutinized under 40A also. If my lords kindly see section 92 BA.
We'll just see the income tax. These are related parties.
So I had certain transactions with related parties, but Indian companies. I had incurred certain expenditure. If my lords kindly see 92 BA, my lords have that?
Yeah,
Capital B, capital A.
that's right.
For the purpose of this section and sections 92, 92C, 92D and 92E, specified domestic transaction in case of an SC means any of the following transactions not being an international transaction, namely clause 1, my lord, if my lords kindly see, has been omitted. My lords kindly see the footnote. any expenditure in respect of which payment has been made or is to be made to a person referred to in clause B of subsection 2 of section 40A. Now, this was earlier there. It was omitted by Finance Act 2017 with effect from 1/4/2017. Now, the assessment in this case has been done after 17, although the assessment year is 16-17. So the question is whether this transaction could have been picked up because of the omission. This very issue, my lord, has been decided by this honorable court. In the case of Texport.
We are technically or legally strictly not going to transfer price.
Transfer price.
It's just a question of law.
That's it. We are not saying it's not a question of law, but it's a question of law which has been already been decided. Madam. Just give.
This issue is covered regarding the same amendment. No, this is not the same amendment.
I'm sorry?
This is not the same.
I'm sorry, my learned friend has given another decision which was relied in Texport. This is the one which covers the very issue.
Very
Very provision,
Very
yes.
deletion.
That's correct. Texport is what my lords may kindly see. My lords have page 3. Page 3, my lords may kindly notice SSC is engaged in export of ready-made for assessment years 13 and 14 and 14-15 were the assessment years involved. Kindly see para 3. It is the contention of the learned advocates appearing for the revenue that tribunal was not justified in arriving at a conclusion that clause 1 of section 92BA of the Act, which had been omitted with effect from 1/4/2017, would be applicable retrospectively by resuming the retrospectivity, particularly when the statute itself explicitly stated that it is to be prospective in nature. As such, they have sought for formulating substantial questions of law and have sought for answering the same in favor of revenue and against the SC. So and so appears. Kindly see, my lord, para 5. Having heard learned advocates appearing for parties and on perusal of records in general and order passed by the tribunal in particular, it is clearly noticeable that clause 1 of section 92BA of the Act came to be omitted with effect from so and so. It should be 17, my lord, not 2019. By Finance Act 2017, 14 is a mistake. As to whether omission would save the acts is an issue which is no more recent negra in the light of the authoritative pronouncement of the Honorable Apex Court in the case of Kolhapur Kenshuga, whereunder Apex Court has examined the effect of repeal of a statute vis-a-vis deletion, addition of a provision in an enactment and its effect thereof. The import of section 6 of General Clauses Act has also been examined and it came to be held as under. I'll skip the portion. Kindly see para 6 at page 8. In fact, coordinate bench under similar circumstances has examined the effect of omission of subsection 9 of section 10B of the Act with effect from 1/4/2010 by Finance Act 2003 and held that there was no saving clause or provision introduced by way of amendment by omitting subsection 9 of section 10B in the matter of General Finance Company versus ACIT, which judgment has also been taken note of by the tribunal while repelling the contention raised by the revenue with regard to the retrospectivity of 92BA1 of the Act. Thus, when clause 1 of section 92BA having been omitted by the Finance Act 2017 with effect from 1/4/2017 from the statute, the resultant effect is that it had never been passed and to be considered as a law never been existed. Hence, decision taken by the assessing officer under the effect of section 92BA and reference made to the order of transfer pricing officer under section 92CA could be invalid and bad in law. It is for this precise reason the tribunal has rightly held that the order passed by the TPO DRP is unsustainable in the eyes of law. The said finding is based on the authoritative principles enunciated by the Honorable Supreme Court in Kolhapur Kenshuga, which has been followed by coordinate bench in this case of this court in the matter of GE Thermometric. As such, we are of the considered view that the first substantial question of law raised in the appeal by the revenue in respective appeal memorandum would not arise for consideration, particularly when the said issue being no more recent.
Okay, now, Now, what is the impugned order here?
Impugned order of the tribunal, my lords, will find
Does the tribunal goes into this aspect?
Yes, yes.
The tribunal
Tribunal
has
follows
It allows the appeal only on this ground.
on this,
Para
on this
11
issue, and this is the only issue that the department also has.
Para 11.1 of the tribunal.
Tell us one thing then, is this issue not covered now?
Your Lordship, it is covered, my lord. We had filed a SLP also, my lord, but that has been withdrawn on the ground of low tax effect, my lord. Tax effect being less than the prescribed limit, we have withdrawn that.
What is the tax effect here?
Here, my lord, it is.
No, what my learned friend is
In
saying
that
is
case,
this
my lord.
order, the earlier order of this honorable post, they have filed a SLP that was dismissed on the ground of low tax effect by the Supreme Court at that point. So as things stand, the matter is covered by a decision of this honorable.
This court.
This court, and which is.
Then why should we continue then?
It has to be disposed of, my lord.
Pardon?
It has to be disposed of.
If the tax effect is more in this case, they may take this to the Supreme Court and Supreme Court.
We
can
will
decide.
follow this. Okay. Now just tell us only for our, this thing.
Yes,
Where are the questions of, substantial questions?
Your Lordship,
at
it is
page 5. of
page
the
5, my
opinion.
lord. I have raised 1, 2, 3, 4 questions, my lord.
Fourth question is slightly different from the first three. First three are basically this issue, my lord. Fourth question is also really academic because Bombay High Court has already taken a view on that.
Item number.
And it's perhaps elementary also. Fourth question really, the question is, the tribunal says that the transfer pricing adjustment should be restricted to AE, associated enterprise transactions, and should not be, adjustment should not be made to non-associated enterprise transactions. My lords, the entire provisions apply only to associated enterprise transactions, and that is very clear, and that's what the tribunal has said. In fact, Bombay High Court has also said, held so. And the tribunal has followed Bombay High Court.
No, but otherwise here the questions of law, the substantial questions of law which have been framed also on transfer pricing.
1, 2, 3, your lordship, the matters which have been heard by the coordinate, but it is relating to comparables issue in transfer pricing. But in this case, transfer pricing, it is not related to comparables issue.
Question of law would have otherwise arisen, but decided already by this court or.
No, but how do we go about in view of the fact?
Your lordship may only say
One
that
of
it is
first three
covered by
questions are
decisions.
covered by decision of this honorable court in that text court. The fourth question is covered by the decision of the Bombay High Court in Thyssen Group, which is what the tribunal has followed. If my lords kindly see Bombay.
Will this not be going into the merits of transfer pricing?
Your lordship, transfer pricing means there are several issues in transfer pricing. One of the issues is relating to comparables, which has been remanded by the Honorable Supreme Court. Your lordship, the coordinate bench has heard with regard to that comparables issue in transfer pricing. But in this case, my lord, there is no such issue relating to comparables.
There is none.
It is only the principles, and
it is only
otherwise a
relating
question
to-
of law would have arisen.
It is a legal issue here.
Point which is being heard.
Can we take the only issue which arises is on the issue of this deleting the provision 92?
Yes, my lord. Only that issue is there in as far as first 1, 2, 3 questions are concerned.
No, 1, 2, 3 relates to that.
Relates
Yes,
to that,
relates to
yes.
only that. It is interlinked with all the three. Now it is subject
Yes,
is only
one is related to omission.
1, 2, 3. All are same, my lord.
Distance of section. So we will only confine this appeal to 1, 2, 3.
Yes, my lord.
Can we say so?
And last question is also relevant, my lord, but that issue has been held against revenue in the decision relied upon by learned senior counsel, my lord, in case
By the
of
Bombay High Court, which is
Bombay-
what the tribunal has followed. If my lords kindly see the tribunal's order.
So we need to answer all four.
All four against the revenue following these two decisions.
These two.
Yeah.
Now, when we are deciding at this stage, we still need to, because admit and we still
Yes,
need
of
to
course.
frame the
That's what the
questions and
Supreme
then
Court
answer.
Yes, sir.
Just say this appeal lays a challenge to the order passed by the ITAT in tribunal in short, dated 6/4/23. IT-80 B Bench Bangalore. In appeal proceedings number IT bracket TP bracket close A number 375/BANG/2021 for assessment year 2016 and 17. The learner counsel for the appellant submits that the following substantial questions of law arises for consideration. It's tough. On the other hand, then a senior counsel appearing for the respondent would submit that no substantial questions of law arises for consideration as the issue in hand, as the issue in hand is are covered by the judgment of the coordinate bench of this court. Just say that with regard to questions 1, 2, 3, and also of the High Court of Bombay with regard to question number 4. So in this regard, he states that the appeal concerns the assessment for the year 2016-17 and primarily relatable to section 92BA.
92BA.
92BA, small Roman 1. Small Roman 1, which provision has been omitted by the Finance Act 2017 with effect from 1/4/2017. The senior counsel states, though the assessment year is prior to the date of prior to the omission of the said provision with effect from 1/4/2017, in view of the judgment of the coordinate bench, wherein a reference has been made, wherein the coordinate bench has followed the judgment of the apex court in Kolhapur Cane Sugar Works Limited versus Union of India, AIR 2000 SC 811, and also a judgment of the coordinate bench of this court in Messrs. GE Thermometrias India Private Limited. What is the full citation of this?
It is not reported, my lord.
But
I passed on a copy of that. GE Thermometrics India Private Limited. It's ITR number 876 of 2008, dated 24.
TR number, just give that, please. The issues, the substantial issues, the issues which have been framed at 1, 2, 3 need to be rejected. The senior counsel also submits, insofar as issue number 4 is concerned, the same is also covered against the revenue in terms of the judgment of the Bombay High Court in the case of Commissioner of Income Tax versus Tyson Group Industries India Private Limited, 2016-70, taxman.com, 329 Bombay. Let's see this issue of 4. What does it say on issue number 4?
So the question, my lords, may kindly see, the question raised is whether the tribunal was right in fact and in law in restricting transfer pricing adjustment to international transaction with associated enterprise only, even when the same is contrary to 92 CA of the Act, when the SSC is providing service to both AE and non-AEs, where SC has not made any bifurcation. My lords, may kindly see the Bombay High Court, page 2. Kindly see the question A. Question is at page 1, para 2. First A, question number A. My lords, get that? Whether on the facts and circumstances of the case, the tribunal was justified in restricting the transfer pricing adjustment only to the transaction between the associated enterprises, which means non-AEs. Kindly see the answer is at paragraph 3, clause D and E. The grievance of the revenue before us is that the adjustment is not to be restricted only in respect of transactions entered into with the AE. All the transactions of the respondent SC would have necessarily be varied, adjusted by the margin arrived by the TPO to arrive at the ALP. We find that in terms of Chapter 10 of the Act, redetermination of consideration is to be done only with regard to income arising from international transactions on determination of ALP. The adjustment which is mandated is only in respect of international transactions and not transactions entered into by SSE with independent, unrelated third parties. This is particularly so. there is no issue of avoidance of tax requiring adjustment in the valuation in respect of transactions entered into with independent third parties. The adjustment as proposed by the revenue, if allowed, would result in increasing the profit in respect of transactions entered into with non-AE. This adjustment is beyond the scope and ambit of Chapter 10 of the Act.
More specifically, paragraph 2A, small a, and paragraph 3D and E. Full stop. On these submissions made by the learned senior counsel for the respondent, comma, the learned counsel for the appellant do not contest the aforesaid position.
Would not dispute, Milord.
Would not dispute the aforesaid position of law.
I'm sorry, Milord.
Full stop. In view of the submissions made, in view of the submission made by the senior counsel for the respondent, and also the stand taken by the counsel for the appellant, comma, the present appeal, just say this, just cut out that. Does not dispute, just thereafter say that, having noted the submission made by the learned counsel for the parties, comma, insofar as issue numbers 1 to 3 are concerned, comma, we find that a coordinate bench of this court in PR, just take this, PR Commissioner, Principal Commissioner of Income Tax 7, and another versus Texport Overseas Private Limited. This is ITA 392/2018 along with ITA 170/2019, decided on 12 December 2019, has in paragraph 2 onwards stated as under. Full stop. Similarly, even insofar as issue number 4 is concerned, comma, the substantial question of law that was framed by the Bombay High Court on an identical issue, on an identical question, that is question number 4 in this appeal, is the following. Just say paragraph 2A. The finding of the Bombay High Court on the aforesaid question can be seen in paragraph 3D and 3E, which we reproduced as under. Full stop. In view of the clear position of law. Now, at this stage, we may state here that the judgment of this coordinate bench in Principal Commissioner of Income Tax and another versus Texport Overseas Private Limited was taken in appeal to the Supreme Court, but the same was withdrawn because of the
being tax effect, being less than the prescribed tax effect.
What do we call it?
Being less than the prescribed tax monetary limit.
Being less than the prescribed tax effect, the same was withdrawn.
Yes, no.
Since the issue is covered by the judgment of the coordinate, the issue with regard to questions 1, 2, 3 is covered by the judgment of the coordinate bench of this court, comma, for parity of reasons, comma, we do not find any merit in the aforesaid 3 questions. Insofar as question number 4 is concerned, comma, this has also attained finality?
Not, no.
They have not, to my knowledge, they have not challenged it, taken it to the Supreme Court.
Your Lordship, I'm not making any submission as regards.
I know you're right. Though the learned senior counsel for the respondent states that there is no appeal. There is no appeal against this?
Not to my knowledge, but there's another Bombay High Court taking similar rule. SLP has been dismissed, if I may, if your lordships.
Just give it to him also.
Yes.
Just see this also on 4th.
SLP.
Does this follow this judgment, Tyson?
This is perhaps before Tyson Group. Yes, before.
No,
after Tyson Group. But it follows the same line of judgments with Tyson Group follows.
Para
If
five.
my lords kindly see para 4. Para 5, my lord. Para 5, the tribunal follows Thyssen Group, which my lords get.
Sure. Just say this, learner senior counsel for the respondent has also relied upon the another Bombay High Court judgment in the case of Commissioner of Income Tax 8 Mumbai versus Phoenix Meccano India Private Limited, 2019. Bracket 108, taxman.com 124 Bombay, wherein according to him, the appeal filed against an order of the tribunal wherein the tribunal has relied upon the judgment of the judgment of the Bombay High Court in the case of Commissioner of Income Tax versus Thyssen Group Industries India Private Limited Supra.
May I just correct that? If my lords kindly see, that tribunal follows its own judgment in Thyssen Group, which has been affirmed subsequently, my lord.
My mistake. Has followed its own judgment in Commissioner of Income Tax versus now this is the same Thyssen.
Same Thyssen.
Same thing.
Same Thyssen. But the issue is otherwise also the same. If my lords kindly see the issue. We have heard both the parties to grievance of the SC. TP adjustment can only be applied to international transactions of the SC with AE and it cannot be applied at entity level. The issue is found to be covered by aforementioned decision of the tribunal in the case of Thyssen Group. Therefore, we hold that the determination of arm's length price should be restricted only to international transaction of the SC with its AE. It was pointed out that the figures.
Same. In the case of Thyssen Group Industries India Private Limited Supra, of which a reference has been made by the learned senior counsel of the judgment passed by the Bombay High Court in an appeal against the tribunal's order. That's right?
Yes.
In an appeal against the tribunal's order. He also states that the judgment in the case of Commissioner of Income Tax 8 Mumbai versus Phoenix Meccano India Private Limited Supra was taken in appeal before the Supreme Court, but the appeal was dismissed.
Yes, ma'am.
We have noted that submission.
Yes, ma'am. I have passed on that. SLP order also. I have passed it on. SLP dismissed.
In SLP number, civil number 2234 of 2018. Dated 5/2/2018. 7/6. Okay. Yes, in view of the fact that the issue relatable to question.
Both the issues.
Question 4.
Question 4, it is covered against revenue.
Question 4 is covered. 1, 2, 3 is covered by the earlier section. Question 4 is covered by the judgment of the High Court of Bombay in Commissioner of Income Tax versus Thyssen Group Industries Private Limited, and also Commissioner of Income Tax 8 Mumbai versus Phoenix Meccano India Private Limited, which has attained finality till Supreme Court, we find there is no merit insofar as question number 4 is concerned. Accordingly, the appeal being without merit is dismissed. That's right.
The questions of law answered in favor of the SC against the revenue.
The questions of law are answered in favor of
the SSC and against the revenue.
Against the revenue. Thank you.
Great.
Just need to keep it in that side.
What is this? There is issue of transfer pricing and my lords, and also corporate issues also arise in this matter. The 5 substantial questions.
We'll await that judgment.
Yes, my lords.
So we'll just say admitted, this is admitted.
My lords, no previous matters have been admitted of this assessee, my lords.
So what do we do? Simply re-notify it.
We can admit the matter, my lords. We can admit this same issues, my lords. There are 5 issues of law, my lords.
I would say, my lord, although it's a transfer pricing issue, the issue is only this. whether compulsorily convertible debentures, interest has to be allowed or not. The view taken by the department or what the department is saying is CCDs are in the nature of equity and therefore interest on that has to be benchmarked. Now, what the tribunal says is CCDs, following various decisions which have said CCDs are hybrid instruments. They are in the nature of debt until they are converted or repaid, or until they are repaid or converted into equity. Only thereafter they become equity. So as long as they're in the nature of that, interest has to be allowed and this thing. So that's the issue. Subject to what my learned friends really outcome doesn't depend on the other matter. If my learned friend wants to argue this matter on some other day, your lordships may. Otherwise, there's the issue because Supreme Court in Sahara has already said that CCDs are hybrid instruments. They are in the nature of course, not in the context of tax, income tax, but CCDs.
Was this issue being argued in that matter? Or?
No.
But shall we await that?
Yes, my lords, we'll await that.
Just see.
But my lords, but if matters are admitted, my lords, then matters all can be heard at once only, my lords. That's my only request.
Admitted.
Yes, my lords.
What is the number, ma'am?
17.
Just say admit.
5 issues of law.
Following substantial questions of law arises for consideration in this appeal. This would be all. What would be the appeal questions?
All 5, my lords. Page 10 of the appeal.
All 5?
All 5, my lords.
Just say all 5. It would be question page number 10 and 11. List the appeal, counsel for the parties to file their written submissions along with the judgment they want to rely upon. List the appeal in due course.
Yes, my lords.
Oh. Thanks. Next.
18.
My lords, for 18, my lords, this is an appeal, my lords, for year 18-19. Respondent have been served, but they're not here, my lords.
18 and 19.
18, my lords. For the assessment year 16-17, my lords, appeal is pending. My lords, that appeal number I do not have, my lords, in fairness, right now. So I've been looking for that appeal, my lords.
Just see, ma'am, respondent has been served.
They've been served.
Despite service, there is no appearance for the respondent. Re-notify. Get also this also tagged along with.
Yes, my lords. My lords, there are.
No, what is the appeal
No,
number?
this is not a per se transfer pricing issue, my lords. This is not a per se not a transfer pricing issue. This is the issue of goodwill. No, my request, my lords, is that for assessment year 16-17, my lords, an income tax appeal is pending. No, I do not have that number, my lords. So I will get that number, my lords.
Get the number, we'll just re-notify.
Yes, my lords.
Possibly you file a memo.
I'll file a memo, my lords.
So that on that day we can take it.
411, sir. 20.
No, this is the issue of transfer pricing, my lords.
This is
Yes, my lords.
admitted.
No, my lord, not admitted. For coming up for first time.
Respondent who appears for the respondent.
They've been served, but they're not appearing, my lords. Startup hours.
Despite service, there is no appearance for the respondent. We'll stop. Where are the questions?
Page 8, my lords.
Now, ma'am.
20, sir.
Having heard the counsel for the appellant, the following substantial questions of law arises for consideration in this appeal. Stop. We say all 3
minutes.
The counsel for the appellant shall file written submissions along with the judgments sought to be relied upon. We'll start list the appeal in due course.
I'm good.
21. 21 is different.
Already admitted.
It's admitted. But who appears for them?
It's morning, the lordships have all, the morning.
So we have adjourned it. We have adjourned it. Okay.
Number 24.
Oh, this is the same, I think, where the counsel was there.
Yes, please.
24.
Where is the counsel? We'll just pass over, let him come.
Twenty-six. 26.
Mr. Rajagopal is called on the court, Manoj, could I request?
You start.
No, my lords, it would be-
Start from the order.
Very well.
It's basically two issues.
Please.
On that additional work. But tell us one thing,
Please, my lords.
no document for that additional work.
They were placed on record, my lords, in terms of certain documents, my lords. Principally, my lords, the issue pertains to anticipatory breach, my lords, and whether I could have terminated the contract based on that, my lords.
But tell us one thing,
Please.
you extended the contract,
Yes, my lords.
huh?
Yes.
For how many months?
It was extended till, my lords, the March of 2020, 2004, please, my lords.
When did you terminate the contract?
In
Within that
December.
extended period,
In December, my lords, it was terminated.
within that extended period.
Within the extended period, my lords.
How can you do it? And where is that order of extension? Letter of extension?
It was a letter submitted by the respondent, my lords.
Have you filed it?
That is on record, my lords.
Show us that.
The respondent, my lords, submitted a letter requesting for extension. It was given. And since there was no development thereafter, my lords, the institute went on to terminate the contract.
How can you?
Under anticipatory breach, my lords, it is permissible, my lords. Under section 39, my lords, it is permissible.
See, suppose he contest, he says balance period is this. And I'll complete the work within this period.
There was no work commenced at all after April, my lords.
That's very difficult.
My
Very
lords,
difficult. And mind it. Arbitrator 34 has
Yes,
upheld
my
the
lords.
award.
I understand, my lords.
Now,
On,
what is the scope under 37?
I understand that, my lords. But on question of law, my lords, the Honorable Apex Court, my lords, on several occasions, my lords, has held that there is power under section 39 to terminate the contract, my lords, on anticipatory breach, please, my lords.
What is the conclusion of the learned arbitrator on merits of the termination? And
They-
find it, he held to be invalid termination.
Yes, my lords. They do not appreciate the concept of anticipatory breach, my lords. That is where I am aggrieved, my lords. That being a question of law, my lords, I am before my lords, my lords. And my lords would be, it would be within my lords' powers, my lords, to interfere on that ground that the concept of anticipatory breach has not been considered, my lords. That is
Where was the plea urged?
that, my lords, is the principal contention, my lords, throughout.
Where?
I'll show before my lords, the
Come to the
contention
award.
regarding anticipatory breach.
Come to the award.
Please. The award, my lords, are filed along with memo, along with documents. my lords.
In the trial court record must have come, the arbitrator report. Come to page 11, not 11.
Issues are framed at page 6 and 7, my lords.
Which is the page you are reading? Now let's see the award, no?
Please, my lords, award, my lords, at page 7 is the issues. This is, my lords, I filed a memo along with documents, my lords.
Which page you said?
Page 7, my lords, are the issues.
Do you have the running page?
I don't have the running page, my lords, I apologize.
Okay, we have the award.
Please.
Which page of the award?
7, my lords, is the issues, my lords. The consideration regarding this, my lords, would get at page 16 and 17. Internal page of the award.
Now, let's see which is the relevant issue. Revocation of bank termination, D.
D, my lords. Whether the termination of the contract by the respondent was illegal. This, my lords, would get the consideration from page 16, 17 onwards.
Yeah, which paragraph? 38?
Paras 37, my lords. states that Exhibit P4, the letter dated 16/8/2003 of the claimant discloses that after discussions in the meeting held on so-and-so, the claimant was granted 4 months extra time for having provided additional 14 rooms and also other additional works. It is not the case of the respondent that this extended period up to 33/2004 was the essence of the agreement. Materials on record disclose that the extension of the period by 4 months is not a concession showed as contended on behalf of the respondent to the claimant by the respondent. Though plan and design of the ladies hostel building construction entrusted to the claimant have not been produced by either parties, Exhibit R29, the copy of the agreement discloses that the proposed hostel building consists ground plus, it should be 3 floors, Malaj. The
2 floors.
Should be 3 floors, because there was there was a modification in the.
That is for the basement. What was extra work was the basement. And this will subject to what you say.
Please.
It appears, at least our reading is, it was ground and 2 floors. Later, the basement was added and the site was also changed. And this period, you extended by 3 months?
No, Malaj, this was, the meeting was held, it appears to be from 13th of August, Malaj. It was extended till the March, Malaj. The March of next year.
Okay. Now read it, this paragraph.
The period for construction of this building was 21 months. That is about 7 months period for construction of each floor. It cannot be disputed that the build-up area of the additional basement floor is not less than any of these 3 floors, in which case the claimant was also entitled to be granted 7 months additional period. But the claimant in Exhibit P4, P5 has stated as further the extra time required for additional works like change of flooring from red oxide.
Sorry, Malaj.
I thought we'll hear him for 10 more minutes.
Very well, Malaj. Kindly, Malaj.
Let him
I'm
start.
sorry, Malaj.
Only just with your permission. Just wait, Mr. Rajagopal, 10 minutes will call.
He's quite competent. I have no complaint. No doubt about it.
Yeah. Yes.
Grateful, Malaj.
So you are clear on this?
Please.
Ground and 2, what was added was the basement.
Yes, Malaj.
Okay, now read it.
It cannot be disputed.
But the claimant.
But the claimant in Exhibit P5 has stated as further the extra time required for the additional works like change of flooring from red oxide to mosaic and additional 14 rooms and its retaining wall excess quantity of EWE and amounting to 20 lakhs will be 4 months, that is up to 33/2004. Having thus extended the period from completing the construction work till 33/2004, the respondent by letter Exhibit R24 dated 30/12/2003 has terminated the contract, alleging slow progress. This action, according to the claimant, was illegal. Exhibit P4 is dated 16/8/2003. In this, the claimant has given the bar chart disclosing different target dates to complete different items of pending works. In Exhibit P5 dated 25/8/2003, the respondent has stated that Shri so-and-so representative of the claimant had assured that the work would be carried out in full swing from 1/9/2003 onwards. Therefore, no importance need be given to the letter of Shri so-and-so dated 21/8/2003, wherein he has alleged that the progress of work was very slow. Shri so-and-so RW1, the resident engineer who was supervising this ladies hostel construction work, has not reported in writing to the authorities concerned that the progress of the construction was slow from 1/9/2003. In the letter at Exhibit R22 dated 10/10/2003, the dean has stated that the claimant had agreed that the progress of the work was below the schedule and hence the claimant was instructed to complete the work by 2nd week of March 2004. This suggests that the dean had no reason to entertain any doubt about the assurance of the claimant to the effect that the construction would be completed by 30th of March 2004. There is no material on record to show that after 10/10/2003, there was any allegation of slow progress of the work. Still surprisingly, by the letter dated Exhibit R24 dated 30th of December 2003, the director terminated the contract, even though the claimant had time till 30th of March 2004 to complete the construction work. As per the decision taken in the joint meeting held on 17/8/2003, the claimant was granted 4 months additional time till 30th March 2004 to complete the construction work. This decision appears to have been taken as the claimant, on the direction of the resident engineer, had put up additional floor, basement floor. Thereafter, no serious complaint was made by Shri so-and-so that the progress of the work was slow or that the claimant could not have completed the construction work by 30/3/2004. Even Shri so-and-so in his evidence has admitted that there is no right to terminate the contract prematurely before the contract period. Since the facts of these two decisions in state of so-and-so are quite different from the facts of the present case, the principle laid down in these decisions are not applicable to the present case. For the aforesaid reasons, I hold that the termination of the agreement by the respondent before the extended period, besides being unjustified, was also illegal. Accordingly, this point is answered in the affirmative.
Where is the anticipated, whatever arguments you were advancing?
Please.
Where is that plea?
This plea, my lords, is that
Is only slow. And the work is so slow that he would not be able to achieve the complete work by that date.
Please.
That's what you want to say.
Yes, my lords, that would be, my lords, the anticipatory breach, my lords. When I anticipate that the contractor would not be able to complete the proposed work within the time stipulated, my lords.
What is the date of termination?
30th/12/2003, my lords. By exhibit R24, my lords, 30th.
But still there were 3 months.
Yes, my lords.
Can complete it?
The work that was pending, my lords, could not have been completed is what was the contention raised, and on that ground, my lords, it was terminated, my lords.
And when did you extend the period?
This, my lords, was extended by letter dated 13/8/2003, my lords. Was the request for extension sought.
So you gave 7 months.
Please.
Coinciding those 7 months for those 3 floors in the original contract, it was 21 months. 7 months each for ground floor and 2 floors. So in effect, there were 3. So you gave another 7 months for this because there is an extra work which has come of the basement. So you gave 7 months. So he could able to. Now tell us one thing, on the date of termination, what was the complete work? What was the work done?
52%, my lords, was completed, my lords.
52%.
Please.
Okay, let's hear Mr. Rajgopal.
After the deemed extension was granted, he did not commence the work at all. What happened, my lords? The contract is of the year 2001. Contract stipulated 21 months from the date of handing over the site as the completion. That is, he ought to have completed by 15/12/2003. Then, my lords, the work was slow work was noticed from April 2003, and several letters were addressed. Ultimately, my lords, on 11th August 2003, stating that only 48% work you have completed, you will not be able to complete the work, and I require this hostel because even the contract itself stipulated at various stages what should be the progress. Then, my lords, he was asked to appear and then show cause as to why the contract should not be terminated. Then, my lords, on 11th August, thereafter there was a meeting. In the meeting, he gave a bar chart as to this is what he is going to do. Thereafter, my lords, we neither terminated nor extended, but it has been treated by the arbitrator as deemed extension. I don't have any say on that. After obtaining such deemed extension, he never recommenced the work. Then, my lords, on 30th December 2003, having regard to the fact that only 48.52% work has been completed, I could reasonably and bona fide come to conclude that he will not be able to complete it by 30th of March. Then, the termination was ordered. Now, what the arbitrator says is this, my lord. There was parties for addendum on one aspect, that the work should be completed before 30th of March 2004. but they are terminated on 30th of December 2003. Kindly look at this, my lords. Even after the extension was agreed upon in principle as held by the arbitrator, for 4 months he never started the work. Therefore, my lords, my respectful submission is, this is a case where section 39 is attracted. And we had to entrust the work to some other contractor and we had to complete it before the commencement of the next academic year. After all, my lords, hostel is required by an educational institution to accommodate the students at the time of admission. Admission process not JEE and all, because this is based on this nationally conducted test, because it is a part of the NIT structure. And it commences in March. And by March, if I do not know how many candidates I can accommodate, particularly girls' hostel, it is a residential college. Even a person who is study, he is from that place also is required to be in the hostel.
Hey, Mr. Rajgopal, we are not in appeal.
Yeah, I am aware of matters. But the only thing is, matters, two findings they give, that arbitrator gives. One is that time was not the essence of the contract. Because I agreed for 30th of March 2024.
Yeah, you agreed for extension.
Agreed for extension means, of course, he has rejected my defense that no extension was given in writing. Even then, my lord, it doesn't mean that 30th March 2024, I need not wait until 30th of March 2024. From August 2003 up to 30th December 2003, if progress is 0.
But you never know, 3 months, I think he could have constructed the building.
My lords, what he has not been able.
You never know. You can't write off. You would have engaged fresh, more hands.
My lords, he was not in the work spot. That is not disputed.
You say he has given a bar chart. His work was not in accordance with the bar chart.
Then not in accordance with is different, my lords. He did not commence the work.
But the still remains prematurely 3 months before you terminated.
Prematurely, my lords, there was a reasonable assessment made that he would not be able to complete the work. And contract provided for that. During the course of working of the contract, if the employer reasonably assesses that work will not be completed on time.
Did you write any letter before termination that this is the...
My lords, except August 2003 letter.
No letter thereafter.
Thereafter, my lord, that we have brought it to his notice that you have not commenced the work.
Wait, you have not. What is the date?
Date, my lords, that is 10/10/2003.
Which page is this?
That is, my lords, in para 41 of the arbitrator's award. Para 41 at page 17.
Yes.
Mr. Ideal RW1 residential who is supervising this lady's hostel construction work has not reported in writing to the authorities concerning the progress of the construction was slow from 19 to in the letter 10/10. The dean has stated the claimant has agreed that the progress was below the schedule and hence the claimant was instructed to complete the work. This suggests that the dean had no reason to entertain any doubt.
And after 10/10, there is no allegation. See,
after 10/10, not 30th December is the...
But 10/10, you tell him by March 2nd week, 2004, complete the work.
That's
right?
Yes, ma'am.
So, you have given a date. Maybe you are slow. Maybe you have not started. But I want work to be completed by the 2nd week of March.
Kindly have a look at the contract notes. Contract says at each stage what is the progress expected of my lord.
If you go by contract, we have 2 questions for you.
Yes, ma'am.
What was the original site? Was there any change in the site?
No site change.
quality of construction, quality, the quantum of work increased by 20 lakhs as against the volume of the work to be done, 1.66 crores.
What we want to put it is this.
Yes, ma'am.
Original contract was for ground floor and 2 floors. Ground and 2 floors.
Original
contract.
contract, my lords, was, my lords may kindly turn page 53 is the contract.
Okay, now at which place? At which place?
At the, within the campus of the NITK.
Very well. Now,
Yes.
come to page 56, paragraph 3 of the impugned order, of the award.
Where, my lords? Page 56 is contract.
No contract, just award only, page 56, paragraph 3 of the award.
Paragraph 3 of the award, my lords.
At the top, the contention of the claimant.
Claimant was, are that after issuing the work order dated 3/3/2001 and after executing the agreement on 12/3/2001, the work site suo motu was changed to a different place, far away from the one described in the work order, that the respondent took about 3 months' time to furnish site plan and design, and also that considerable time was taken to clear the trees in the new site by the respondent, that ultimately vacant site was delivered to the possession of the claimant by respondent only on 6/6/2001, that as soon as monsoon has set in by, that time, he could not start construction of the hostel building and till the end of October 2001, that thereafter the claimant carried out construction of work to the satisfaction and thus has completed 65% of the construction work for which it is still. This is, my lords, contrary to record.
Is it your case that original contract was ground and 2 floors?
My lords,
It was increased.
my lords, the increase was not as substantial as the arbitrator has arrived at. If my lords would kindly see the contract itself, my lords, at page 53 of that paper book, my lords, that I have filed memo along with documents. The original contract value was value of work to be done for 1,66,66,000.
We want to know.
Yes, ma'am.
What was the work to be done?
Work to be done, my lords, the work to be done is the in the work order, my lords.
Where is the work?
Description of work, my lord, that must be only in perhaps in the NIT, my lords, which is not part, which
No,
is
it
not
would be here. How can that be?
Yes, my lords. In the contract, my lords, I find, except giving the quantities, my lords, at page 105, Schedule B.
How can that be?
Description of work is not forthcoming in this page.
But without a description of the work, the contract has been awarded.
No, my lords, there would be, my lords, because the contract will generally say what are the documents forming part of the contract.
The nature of work, the description of work,
Yes.
it should be the otherwise. Okay, very well. If it is, doesn't say, I will say you were to construct 10 floors. How would you challenge that? How would you say no? The basic And more so when the allegations are that it was ground plus 2 floors, which was increased to 1 more basement with 15 rooms. Now, is it your case? Is it your case that basement was later added? Basement was later added. Interestingly, going by the, at least the order of the learned trial court judge, yes, there is no document for the increased work. No one has produced.
No one has produced, that is, my lord, sir. Actually, it would have been recorded, my lords, at least in the work order book maintained at the site by the resident engineer. It should have been maintained. Sorry, my lord, sir, now, can I get the assistance of the engineer from, I'll get the concerned person who was working as engineer at that time.
We'll tell you, we are in a different regime. We are in an arbitration award.
Yes, my lords.
Scope is limited, 34 is limited, 37 is in any case.
Yes, my lords. I am only on 2 issues, my lords. Whether the arbitrator,
All associated.
my lord,
buildings.
all, I am only on 2 issues, my lords. On whether arbitrator could have held that anticipatory breach clause could not have been invoked in the facts of this case. Second is, my lords, the contract provides for interest of 6%. The awarded contract interest is 12%.
Okay.
Third is, my lords, a date was set for the contractor after the termination of the contract to take away his plant and machinery or whatever it is there. He doesn't come. Then, my lords, arbitrator awards that I have to return the plant and machinery, my lords. After all, what would be the plant and machinery? A concrete mixer. In the year 2003.
So there may be others of stuff also.
Other, my lords, scaffolding material may be there.
Scaffolding.
Yes, my lords.
Fixture.
That the orders, I have to restore it to him in working condition. And this award is passed after about 7 or 8 years.
Now tell us, what is the position of the award?
Award has not been, there has been stay of the award through. LCR has been called.
And this award relates back to 2009.
Yes.
And the dispute is of 2003-4.
2004, 2003, my lord, sir, because cause of action arose on 30th December 2003.
Let's see what are the directions given in the award.
In the award, my lords,
How many claims were made and how many claims have been allowed?
my lords, almost all the claims have been allowed except, my lords,
Tell your position.
that, except the other construction materials which he claimed to the extent of 3,79,000. Rest all have been, my lords, the award is in the documents I have filed is at page 1, and the operative part of it, my lords, is at page
Now,
40.
Have you handed over the machinery?
My lords, whatever was available, he was asked to take it.
After the award,
After the award, my lords, there was no machinery there.
what happened?
My lords,
At least junk was there.
junk was there and he was free to take it.
Was free to take it. Did you ask him to come and after the award was passed to come and take possession, take it away?
That does not appear to have been done.
Because he says working condition. The arbitrator says
My
working
lords,
condition.
para 107 of the award, my lords, my kindness.
Working condition.
Working condition then.
Otherwise 18%. Now, how would you value the property? How will you value the machinery now?
Is the machinery, my lords, at that time, whatever was the value.
Whatever is the market price now?
No, it is not replacement value. It
Right.
cannot be replacement value. It can only be depreciated value.
proceeds on the same with interest at 10% and the sale proceeds of the same. Did you sell it?
No, my lords, we have not sold also.
And where is it lying today? Where is the machinery lying?
Machinery, my lords, there was absolutely not this one, and in fact, about the machinery.
Rajgopal will do one thing. Please get your instructions.
Yes, my lords.
Where
3
is the
lakhs.
machinery? Is the machinery actually available physically? It is
I'll
not,
get my.
you have sold it. If that has also
Okay,
not
we have
been
not
done,
sold it, my lord, that much I am sure, my lord,
it may
because
be, it may be junk.
my client is not as active as that it would have
What
sold.
is described in the measure in good and working condition? Inventory. That must be inventory.
Inventory has been taken, my lords, on,
If inventory has been taken, he has not collected, where is the machinery?
on 16/1/2004. Inventory has been taken.
Inventory prepared. It's on the side. He doesn't come to pick up.
Yes, my lord.
Neither you have sold. Where is it?
I'll get instructions.
See, these are some unanswered issues. And what is the case? They return it in working condition, otherwise sale proceed. How is he presuming the learned arbitrator it has been sold? But you must get all these clarities on this. Let's be very clear. And what was the banking interest at that time?
Yes, my lords.
During between 2003 and 9?
Interest he claimed was 18% he claimed.
No, he must have claimed. Is there any contractual interest?
Contractual interest is 6%, my lords. That my lords would get at page 9 of the
So
contract.
you can argue he could not have given.
More than 6%. That is one.
But to that extent, some discretion lies with the arbitrator, but be that as it may, that's only possibly you can argue in the absence of any stipulation in the contract.
Yes.
There is a discretion lies. But when the-
Discretion would not lie, my lord, because the section 37 starts with the, that unless otherwise agreed.
So that's what you will argue. It is 6%.
That
It
is-
could
that's
not
the-
have gone.
In fact, my lords, may I, frankly, my lords, on anticipatory breach, I accept, my lords, that a notice ought to have been issued in November or December. There, during the discussions, their explanation was that we have told him several times, sir. But that is not there on record.
But there is no such plea advanced.
Yes, my lords.
There is no plea advanced before the learned arbitrator.
Arbitrator, my lords, it has been said that it was this, even unfortunately, my objection
But
statement.
that I don't think, Mr. Rajgopal, you can really able to justify a premature termination.
On
Very well, you take complete instruction. Let's see what happened to the inventory, everything.
very well, silent.
Who is the counsel?
My lord, he is on trial, Yashodhar Hegde.
The counsel?
It shows the name of the council. It shows that.
Yashodhar Hegde.
So that
When do you want, Mr. Rajgopal?
2 weeks, I mean, because I have to get the concerned officer as retired from service, I have to get him.
This institute is Bangalore based?
No, but it's in Surathkal, that is near Mangalore.
Oh, near Bangalore.
This is original, one of the original 6 regional engineering colleges,
Yes, sir.
which I failed to enter as a student. Later I became.
So this must be an old institute,
It is started in the year 1966 months.
but you continues to be still associated in a different status. Okay. Just say that, Mr. Rajgopal and the senior counsel has commenced his arguments at his request, re-notify. His request to take instructions, re-notify. When the counsel on this day, when the counsel for the respondent shall be present in the court. Okay?
Great,
29/10.
great.
We are through. Any pending?
20.
Lordship, serial 28 was pending, Lordship.
Yes. Where is that, which is that Passover matter, man? We just call that.
24, serial number 24. 24.
Where is he? He was here, or shall we take it after lunch? We'll take it after lunch.
As your lordship.
We'll take it after lunch. Let him, possibly he may be under the impression we'll take it after lunch. We'll take it after.
Very well.
28.
Yes. Got the judgments?
Yes.
Now, the proposition which you are advancing is this.
Yes.
Till such time, the assessment is
Concluded.
if I concluded, whatever you may call it, review, this, the same would hold, having attained finality, the same would hold good against the SSE.
As well as us.
And the SSE on a different ground,
And see,
or on a ground that the law being this, there is no liability which will fall upon the SSE, can seek the refund. That's the submission.
my lord, he can't seek the refund.
That's what.
That's,
He cannot seek the
he
refund.
cannot seek refund unless, my lord, the assessment is modified.
What does the judgment say?
The judgment says the same, my lord. Lordships may, the first judgment, your lordships may kindly see, my lord, Priya Blue Industries. Next page, your lordships may kindly come to that.
Whether this ground was available at the time of assessment.
This ground was available at the time of, my lord, the pending proceedings, my lord,
Pending assessment proceedings.
proceedings. Even appellate proceedings also, Lord, this ground was available.
But not taken, Your Lordship.
By you.
By the department, Your Lordship. They have not.
This submission is on you.
2 points, Your Lordship. One is assessment of duty. When the Supreme Court has held that the levy itself is unconstitutional, it ceases to be duty. The characteristic of duty is all gone, Your Lordship.
But tell us one thing.
Yes, Your Lordship.
Inter se parties, the assessment has attained finality. You may be right on a question of law, Supreme Court decides. Inter se parties, the assessment having attained finality, neither you have taken in appeal that particular assessment order. Inter se parties has attained finality, now you can't seek the refund.
That's the, my lord, the proposition.
See, that's the normal proposition of law also. Just let's take, for instance, today we are concerned with assessment. A writ petition or a suit on a particular point. It attains finality. Neither you have taken, you did not succeed in the writ jurisdiction before the single judge. You come to division bench doesn't interfere. You go to this third party goes to Supreme Court, but you did not go. You stopped till the High Court, the division bench. That issue qua you has attained finality insofar as that assessment is concerned. Maybe in a subsequent judgment, the Supreme Court, with regard to a different SSE, says that this kind of a levy or whatever you may call it is unconstitutional. Can you on that basis seek the refund, saying that though I did not succeed on that ground, neither I have urged that ground at the time of assessment proceedings, but now the Supreme Court has held that kind of a levy is unconstitutional, please give back or refund the money. Can you ask, can you argue?
Your Lordship, 2 points on this. There were similar matters that were placed before the Telangana High Court and the Bombay High Court. So the proposition is, if I have not challenged the assessment, and subsequently the Supreme Court renders the entire transaction or the levy to be unconstitutional, whether I will be in a position to piggyback on those petitioners who succeeded before the Honorable Supreme Court. So, Your Lordship, the point is over here.
That's what we are putting it to you. Can you?
Grateful, Your Lordship. My submission is threefold over here. The first point is, these assessments that happened are in the bills of entry that were filed were in 2017-18 and subsequently, Your Lordship. The Supreme Court had rendered the levy unconstitutional in the year 2015 itself. So therefore, I'm relying on two decisions which say of the Telangana High Court and the Bombay High Court, which say that when the Supreme Court has laid down the proposition, it was incumbent on the officers to have accepted the documents and this was under customs, Your Lordship, where where the high courts have held the department. It was incumbent on the department to ensure that the Supreme Court's decision was followed. That is one aspect of it, Your Lordship. Now, the primary argument of the, I'll just 2 minutes, Your Lordship, I'll just finish my argument.
Yes, go ahead.
The primary argument of the department in the first adjudication stage, the first appellate stage, and before the tribunal was only twofold. A, while the Supreme Court held the levy of 1% to be unconstitutional, the consequent amendment that happened to the rule makes any benefit only prospective in nature. The submission was nullified by the tribunal by saying, when the original rule itself was held to be arbitrary and unconstitutional, and the Supreme Court held that it will read down the provision.
Okay. How many cases would be there of this nature?
Lordship, insofar as this particular issue is concerned, this was only one set of bills of entry where the claim of refund was made. It was not a recurring issue.
Not many, my lord. Not many, my lord. This is
Now, but tell us one thing.
not many. This is only two.
Future, after the Supreme Court has set aside holding unconstitutional, for future, you were not charging that 1%, whatever the levy.
No, Your Lordship.
So you may be right on a proposition of law. Once it is unconstitutional for all purposes.
Yes, Your Lordship.
It will relate back. It is
Yes,
as
Your
if
Lordship.
that provision doesn't exist. You can
That's
argue
the submission, Lordship.
right? But the assessment for which you are seeking, of the year of which you are seeking the refund, has attained finality, then what?
Lordship, therefore, it is the show cause notice which initially proposed the rejection of the refund claims should have explicitly stated that the reason for rejection of the refund claim is on the ground that the assessment has not been challenged.
Okay.
Neither at the adjudication stage nor at the first appellate stage or the tribunal stage, this argument that the assessment should have been challenged in the first place was taken. Therefore, Your Lordship, this is an argument that is being taken for the very first time. And my lords are aware, I've already laid down the law saying that the show cause notice becomes the primary source of the list between the taxpayer and the department. So if the allegations either proposing to confirm a demand or proposing a demand or rejecting a refund does not contain a specific ground, the department cannot be permitted to raise a completely new ground at the stage of appeal. If I was given the necessary opportunity at the adjudication stage, perhaps at that point in time, I would have filed an application for amending the bill of entry, which would tantamount to challenging the assessment. Lordship, much water has flown.
Just 1 minute.
Yes, sir.
But here,
My lord.
here, there is no declaration of any particular levy as unconstitutional by the Supreme Court.
Yes.
That's there.
That's the difference between this and that case.
Ah.
Your Lordship, may I kindly see, my lord, next case, my lord, next case law. Lordship, that's 2 pages.
Yes.
Then my lords may kindly come to page numbers are given at the bottom, my lord. It's very
Yes, page number
17. My lordships may kindly come.
No, we don't. Pagination is at the top. No?
No, my lord. The lordship may don't see the pages at top, my lord, bottom, my lord, printed.
Yeah.
I see.
Paragraph number.
My lord, paragraph number 43. As the order of self-assessment is nonetheless an assessment. In this case, my lord, this is an order of self-assessment.
Now, what is the limitation for reassessment or review of assessment or modification of assessment?
My lord, appeal. There is no review of the assessment.
But whatever is the modification.
Yes. The next stage is an appeal under section 128.
What is the limitation?
My lord, limitation is
Lordship, the first point is
30
amending the bill of entry under section 149, for which the Supreme Court
149,
has.
there is a provision to amend the bill of entry so that, my lord, the self-assessment gets modified. That is the time period. If it is not done, my lord, he has to file an appeal under section 128. My lord, 60 days. The first is, my lord, the 60 days is the period of limitation.
When did he file the refund? Now, assessment was of the 2 year, which year?
17-18, my lords.
When did the Supreme Court judgment came?
2019, Your Lordship, ITC in 19.
19. And refund application was?
My lord, that immediately, my lord, within 6 months or of the
Yes.
time prescribed under the statute.
And why? What was the occasion for the Supreme Court to say one SSE had taken the issue to the Supreme Court?
Your Lordship, the unconstitutional levy, Lordship. Yes, Your Lordship. In 1990, there was a notification which said that the 1% handling charges would be applicable even if the actual handling charges are not ascertainable. The decision of the Supreme Court in the case of Wipro had filed challenging that valuation before the Madras High Court initially. He failed before the Madras High Court. It was taken on appeal before the Honorable Supreme Court. And in 2015, Your Lordship, the Honorable Supreme Court struck down that Rule 9, subsection 2.2, where they read down the provision to say 1% handling can be applicable only if the actual value is not ascertainable. In all my cases, Your Lordship, handling was explicitly ascertainable. So therefore, the Honorable Supreme Court's decision applies squarely on the present case. In my case, I paid handling, which was part of the CIF value. On top of that, the department wanted the 1% handling charges, Your Lordship.
We'll come back after lunch.
Obliged, Your Lordship. I'm grateful.
Yes.
I'll have-
Did you check up?
May I please, Your Lordship?
Just 1 minute.
Yes.
Wednesday,
We'll have it day after tomorrow.
please.
I-
We will have it day after tomorrow.
Please, please. Memo I am putting along with documents.
Say at 4 PM.
Please, 4
My lord, memo may not be maintainable. I'm appearing.
For the respondent, huh?
Yes,
No,
sir.
have they filed, you filed any application?
No,
My
they
lord-
have not filed an application.
My lord,
There are some serious
My lord-
allegations against the officers.
No.
They
You
can't be
file
on
an
my
application, not like
Application, my
this.
lord.
my lord, I'm prepared, I have prepared application, my lord. Only, my lord, for,
No, you will prepare an application, file it, then mention it and give a copy to him,
my lord, I have already given, my lord.
not on the basis of memo.
My lord's direction was
My
to
lord.
furnish a bank guarantee to the extent of the 50% of the duty. And for remaining 50% of the duty, my lord, solvent surety. They have complied with one condition. They have furnished the bank guarantee.
We say nothing,
Yes, that's,
not allowing it, take it, you will file an application,
My lord.
serve a copy on him,
Please,
then mention it. If you want urgent listing, we'll consider
my
it.
lord, kindly have it on Wednesday, is only for, memo for
Not
quoting,
saying-
my lord. Separate application I'm going to file, my lord.
Will not
Because,
say so. First, file an application and mention it tomorrow morning.
please,
We have
please,
no issue, but give a
Great.
copy to him.
please,
But you will file an application. We want a proper application to come on.
please, please, please. Great, great,
Okay,
please.
next, just call. Yes, Mr. Hola, come, Mr. What is this, Mr. Chinnappa and Mr. Hola?
Withdrawal.
You were the appellant.
Yes, I'm the
You are
appellant.
the appellant.
Yes, respondent is my learned friend. This was against, my lord, an interim order was refused by the trial court, commercial court. So we filed an appeal against that. That suit itself has been withdrawn in the morning today.
Do we have it, man? Do we have that appeal?
This is, my lord, the memo we had filed in the commercial court and they have,
Mr. Chinnappa, you represent all the respondents?
No, Lord, I represent this 1, 4, and 5. But in any event, Lord, the original commercial suit has been withdrawn this morning.
Which was the order of
Yes,
which is
Lord.
the subject matter?
Yes, since that is withdrawn, Lord, it's only consequential.
Goes.
Oh.
Very well, that's it. Now you are the appellant, you want to withdraw it, withdraw it.
Sure.
But who are there, other respondents?
And for respondent number 2.
One who appears,
I, one.
one for all the legal hairs it appears.
The-
Yes, no, the trust, they say trustees.
trustees, my lord.
Okay,
I represent 1, 4, and 5. Lord. I represent respondent numbers 1, 4, and 5.
These are the appellants, my lord. Trusts are all the appellants before my lords.
The trusts are the appellants.
trusts are the appellants.
Yes, my lord, along with Mr. Vijay Kirloskar and my lord electric. If my lords come to my lord page 9, my lord sees Vijay Ravindra Kirloskar, my lord is the first appellant. Then my lord 2 to 6, my lord are the trusts. Represented by their 3, my lord, trustees, Vijay Kirloskar, Hunnur and Prakash.
Now you represent one.
Respondent number, my Lord,
One.
1. Respondent number 4 and respondent number 5.
And what about the others?
For respondent number 3.
Two you represent,
For respondent number 2.
three you represent, 4 and 5, Mr. Chinnappa, who is for 6?
The company.
You represent 7 to 10. So only thing is 6 is not there, that's all.
Yes. 6 notice.
Not a contesting party? Okay, but in any case,
Suit itself is.
we will just say this. Mr. Holal and a senior counsel appearing for the appellants as briefed by so-and-so. Has filed a memo for withdrawal. of this appeal. The memo of withdrawal reads as under. Full stop. The learner counsel for the respondents who are present in the courts states that they have no objection for the withdrawal of the appeal. Now, who is the contesting party? Everyone is contesting.
Yes.
My lord, strictly speaking, first,
One is the main contesting party, but in any event, Lord, they have, of course, everyone has also has argued. at length.
Says they have no objection for the reason that the very suit from which the impugn order has been passed, has been withdrawn. Full stop. The appeal is dismissed as withdrawn. Just say that any of the IAs are there, become infructuous.
yes. Right.
All have signed, na?
Yes, my lord.
All
All the
have-
appellants have signed, my lord. All the appellants. Please.
This says that the memo of withdrawal duly signed by the appellants and their counsel. Mr. Shetty.
Please, my lord, court office,
Huh?
court officer just,
Yeah, we found the appeal is dismissed because
Please.
of the non-compliance.
IA,
What is there is IA.
IA is there, my lord.
So we will only dismiss that IA as,
Doesn't arise for consideration.
it doesn't arise for
In
consideration.
view of the main appeal itself has become infructuous in view of the order of the Supreme Court. If that is,
That's how we have to take a long route. Just say this, ma'am, who has taken the morning dictation, ma'am? Do we have that copy? Draft hai? Huh? No, it's not. But who has, Pajwan has taken? Then you say, let him not type it out. Just say this. Was anyone present in the? morning?
no, ma'am.
Just say this, Mr.
Yes.
Just say this, the Mr. Shetty has filed memo of withdrawal has in MSA 81 of 2018 filed a memo of withdrawal annexing therewith order passed by the Supreme Court in dated 16/8/22 in special leave to appeal bracket criminal number 4258 of 2021. The memo reads as under. To stop, suffice to state that the appeal was dismissed for appeal was dismissed on 15/3/2020, on 17/10/22 and 15/3/2023 respectively for non-compliance of the office objections. Though an application for recall of the said orders, applications have been filed, Mr. Shetty states that in view of the order of the Supreme Court in the SLP criminal dated so-and-so, the application, he shall not press this application as.
Does not survive for consideration.
This application doesn't survive for consideration as the appeal which was dismissed, for which recall application has been filed. Has become infructuous. Has rendered, shall be rendered infructuous. Shall be rendered infructuous. Stop. Noting the submission, IA number so-and-so, ma'am, dismissed as infructuous. That's where we put it.
Please.
Okay. Thank you. Ma'am, these are IAs now. IAs 1 of 24 and 2 of 24 and 1 of 24 and 2 of 24 in both the appeals.
Please.
are dismissed as infructuous. Thank you. Man. Not the next, like this one. Yes.
28.
Before my learned friend commences,
Where is the counsel?
unfortunately, even looked for him outside.
Pardon?
I even looked for him outside, was not able to cite.
Which is this number?
24, man.
Yes. What are your instructions?
My lords, we take a letter from the client with the signature. We handed over the files to him. I enclosed the letter along with that memo also. my lords. Kindly.
So what do you want?
We are
The last order, the court doesn't permit you to withdraw yours.
Special entry.
the appellant is not interested to pursue the matter. Madam. That is the reason.
That's the reason.
Yes, ma'am.
Shall we record it?
Yes, ma'am.
Is the letter on record?
Yes, ma'am. There is a letter.
Sure.
Yes, ma'am. He made a signature in the memo.
Oh, this is long. But
This memo for returning. This memo for returning.
no, where do they say that he is not pressing this?
Well, this is a signature. We went to his place. We took a signature and we came back. my lords.
What it says? What it says?
He said he is not interested.
Where is that? Where is that, mister?
My
Where
lord-
it says?
my lords, this is a
Where does
letter.
he say he's not pressing, he's not interested in pursue the appeal? That's what we want.
Yes, ma'am.
Where does he say?
There. Oh, yes. In copies.
Are you ready to make a submission statement that you have instructions to withdraw?
I'll make a application saying that I'll make a application, my lords, withdraw.
One thing,
Yes, ma'am.
we don't want that it should come on you also as a counsel.
Yes.
Prepare, don't press your memo for retirement. Prepare a memo for withdrawal if your client says so. Don't go by our words.
Yes, ma'am.
If your client says so, you will say so, that you have instructions from so-and-so
Yes, ma'am.
that he wants to withdraw the appeal.
Yes, my lord.
Allow, we will take it. But you have to allow, withdraw this memo for retirement. We will not permit you to make a statement during the pendency of this, or otherwise we will reject it.
Yes, ma'am. I'll file a memo. Kindly reject this retirement memo.
It's already been rejected.
Your memo for retirement has been rejected.
Yes, ma'am. I'll file a fresh memo for withdrawal.
Withdraw.
Yes, my lord.
Do it. Come tomorrow.
Yes, my lord.
At the request of counsel for the appellant, re-notify tomorrow.
15:10.
Yes, now, which judgment says
Yes.
that if there is a change in law, there are judgments. If there is a change in law, that issue attain finality. Because there is a change in law, see, a judgment will not give you a cause of action.
That's the
Change in law Because there are judgments, possibly. I have
Concluded proceedings cannot be reopened by virtue of a change in law and subsequently, my lord, that's,
The argument is.
yes.
The very foundation has gone of that assessment, which though I have not challenged, am I entitled to refund? Simple. That's the submission, the very foundation. That's unconstitutional. It is as if there is nothing against, there is no such provision exists, cannot exist.
Your Lordship, the Honorable Supreme Court, in its constitutional bench, Your Lordship, my learned colleagues are there who will hand over the decision of the Honorable Supreme Court in the case of Mafatlal versus Union of India, Your Lordship. It's a constitutional bench decision.
That deals with the refund issue again.
It's also a refund issue.
Unless, my lord, the
I'll take
provision
my
is
lords through the
held
very
to be
provision.
unconstitutional or levy is held to be unconstitutional, there is no cause of action for seeking refund.
No, it doesn't
So
say that.
in the case, if the provision is held unconstitutional, my lord, the refund can be, my lord, granted, my lord, that's what the purport of the judgment.
If I could request my Lord's attention to page number 9 of
In
the
all
decision.
cases where, my lord, the provision or a levy has been held unconstitutional, he is entitled for a refund. Otherwise, my lord, he has to undergo the, my lord, the procedure contemplated under the act. That's the, my lord, the purpose. I think that's the proposition he wants to canvass, my lord. That's the.
I'll read the very language, Your Lordship. The Honorable Supreme Court that has laid down this
500, 600 page judgment.
No. It's only 3 paragraphs, Your Lordship. It's only 3 paragraphs. The very proposition. Page number 9, Your Lordship. Paragraph 16, Your Lordship.
Yes.
Yes.
My Lord, the paragraph starts with Article 265. My Lords have it?
Yes.
Grateful. Article 265 of the Constitution is declaratory in nature. It says that no tax shall be levied or collected except by authority of law. This no doubt means that taxes collected contrary to the law have to be refunded. But where a taxing enactment contains provisions providing for and governing the refunds collected without the authority of law, the validity of such provisions, if and when questioned, has to be examined with reference to other provisions of the Constitution. Article 265 does not itself lay down any criteria for testing the validity of a statute. When it speaks of law, it no doubt refers to a valid law. But the validity of a law has to be determined with reference to other provisions in the Constitution. We must, however, pause here and explain the various situations in which claims for refunds may arise. They may arise in more than one situation. This is important, Your Lordship. One is where a provision of the Act under which a tax is levied is struck down as unconstitutional for transgressing the constitutional limitations. This class of cases we may call, for the sake of convenience, as cases of unconstitutional levy. In this case, in this class of cases, the claim for refund arises outside the provisions of the Act, for this is not a situation contemplated by the Act. Second situation is where the tax is collected by the authorities under the Act by misconstruction or wrong interpretation of the provisions of the Act, rules and notifications, or by an erroneous determination of the relevant facts, that is, an erroneous finding of fact. This class of cases may be called, for the sake of convenience, as an illegal levy. In this class of cases, the claim for refund arises under the provisions of the Act. In other words, these are situations contemplated by and provided for by the Act and the rules. Paragraph 20, Your Lordship. So far as the first category, unconstitutional levy, is concerned, there is no dispute before us that it is open to the person claiming refund to either file a suit for recovery of the tax collected from him or to file a writ petition under Article.
Tell us.
Yes, Your Lordship.
Why did you challenge the levy? Why did you, at the time of assessment, challenge the levy on the ground that it is unconstitutional?
Lordship, because Lordship, the Supreme Court, if I could read the provision of the decision of the Honorable Supreme Court in this very case, Lordship,
no,
on this issue.
But this plea was available to you.
Lordship, yes, I agree, Your Lordship. I go down to the.
But you don't, it's like, sitting on the fence. I don't succeed, but there I succeed, I'll go that side.
No, Your Lordship, the submission that I'm trying to make is this is a decision of the Constitutional Bench which says unconstitutional levy is outside the provisions. Therefore, Your Lordship, in 2015, this levy of 1% of handling 1% of FOB value on handling was struck down or read down as being unconstitutional, ultra vires of Article 14 and Section 14 of the Customs Act.
Yeah.
Thereafter, Your Lordship, insofar as the payment, while the bill of entry was passed, Your Lordship, the submission, the assessee continued to pay this 1%. I admit, Your Lordship, that they did not file a writ petition because at that point in time, the amendment already happened.
Post 2015, you were not paying that 1% ad hoc, whatever is the levy?
It was paid, Your Lordship. It was paid, Your Lordship.
No. Were they still insisting upon for you to deposit? No.
For clearings, Your Lordship.
No.
Because
but after the Supreme Court judgment, were they claiming that amount from you?
Yes, Your Lordship. The reason is the department, only by virtue of notification 19 of 2017, which is 26/9/2017, they amended the rule. Originally, the rule read payment, it continued, that rule of 1%, even if it is not unascertainable, continued to persist in the rules despite the Supreme Court judgment striking it down. And the amendment to that rule was made only in 2017, even though the Supreme Court's decision was rendered in 2015. So therefore, Your Lordship, because the bills
we are concerned with which period, which way bill?
The bills of entry, Your Lordship, were filed for the period 2017, Your Lordship. During the subsequent.
By that time, the Supreme Court judgment was there.
Yes, Your Lordship. By the time the Supreme Court had passed the.
Tell us one thing.
Yes, sir.
And this assessment year is which year?
2018, Your Lordship.
Then
I filed.
Tell us one thing. Then why did you pay despite the Supreme Court order?
Lordship, sometimes what happened, Your Lordship, till the time I pay this amount, the clearance is not permitted, Your Lordship. The clearance from the customs is not permitted till the time this payment is done.
Then you should have come to the High Court.
I completely go down to that, Your Lordship. I admit that as per the Supreme Court.
So effectively, you should have come, and once you did not challenge the levy also at that relevant point of time of 2018.
2000, yes, Your Lordship. Because by then the Wipro decision had already read down the provision to mean that the 1% FOB value is applicable only when
How much is the amount?
40 lakhs, Your Lordship, approximately 40.5 lakhs.
41 lakhs, around 40 lakhs 50,000 or 41
Yes,
lakhs.
40.58 lakhs, Your Lordship. In fact, the submission that I wanted to make, Your Lordship, in addition to the merits, the department had never raised this ground of the assessment issue, either at the show cause notice level, which forms the foundation of the dispute between the assessee, or the purpose for which the refund application was rejected. Nor did they make this submission even in the adjudicating order or the appellate order, Your Lordship, or even before the tribunal. This is the first time.
Your whole ground was that scripts.
Yes, Your Lordship. In fact, the
No, my lord, whatever, why they, my lord, they paid this 1% handling charges. Yes. They wanted to, my lord, the scripts were available to them.
What is this concept of scripts?
My lord, they give a benefit.
DEPB scripts, Your Lordship. When you are making.
My lord,
1 minute.
Scripts. My lord, they give a benefit, which is in the nature of, my lord, some a note or a script, which can be utilized for the purpose of, my lord, discharging the duties. Now, if suppose they are unable to, my lord, discharge the duties out of utilizing those scripts, my lord, they can seek refund of it. Now, what they have done is, they wanted to, my lord, they didn't utilize these scripts. They were lying. either they would have lapsed. So they paid this duty. Seek a refund in cash by utilizing these scripts. Seek a refund in cash. Unless, my lord, script is converted into a cash, it is of no use. Except, my lord, those scripts could be utilized for the payment of tax. My lord, it is some kind of a export benefit which they have in the customs. Now, if those scripts could not be utilized for any other purpose, my lord, what they did is they paid this 1% handling charges by utilizing those scripts.
Okay.
So they wanted to, my lord, exhaust that, the points or, my lord, whatever the benefit which they were there on record. So they wanted to, my lord, utilize that. For that purpose, my lord, they paid the duty by utilizing those points or scripts which were available to them. Now, my lord, they indirectly wanted to encash that one.
No.
Because, so they made a claim for a refund.
No, Your Lordship,
We did not raise any demand for, my lord, this amount. There was no demand from us. Nor we have taken the matter for reassessment on non-payment of this 1% handling charges. It is on voluntary payment by utilizing those scripts which were available to him. Now he wanted to convert that into a cash. That is the purpose of, my lord, filing a paying it and taking a refund.
Your Lordship, the intentions that my learned friend is attributing to the entire transaction, I think they may not
And
be
my lord,
correct.
Your Lordship, it is very important, my lord, the chronology of events after this, my lord, whether the appeal could be, my lord, heard on these grounds and all. Why, my lord, I'm saying is this. My lord, refund claim was rejected on, my lord, the 11/5/2018, first refund claim. Then, my lord, sir, he files an appeal before the Commissioner Appeals. My lord, on 15/11/18, Commissioner Appeals remands the matter to the original authority. My lord, after the remand, the original authority once again rejects it on 26 to February 2019. My lord, that's one round of this thing came to be over. Now, my lord, in the meanwhile, what the importer does is, the Commissioner Appeals order remanding the matter back to the original authority, he challenges before the SESTAT, saying that, my lord, Commissioner should not have remanded the matter because facts were very clear and law is very clear. Now, my lord, the SESTAT allows his appeal, remitting the matter back to the original authority again, says that you grant a refund for a purpose of calculation, etc., examination of a documents, it is remanded to you. After the remand, for the second time, on 29th January 2020, original authority again rejects it by citing this, that since the assessment is concluded, I cannot sit on the assessment order. I have to follow the judgment of the Supreme Court. He quotes the, my lords. So, my lord, now the latest order is 29/1/2020. After the remand of the, my lord, the SESTAT. Now we are in, my lord, agitating the order of the SESTAT before this honorable court. Something has passed, my lord, beyond that. Now, whether the appeal could be heard on these things, my lord, that's also a matter for examination. Because SESTAT order.
What is your case on merit? Refund is the benefit of some scripts was being taken, the points against those scripts was treated for seeking the benefit in cash.
No, Your Lordship. If I may be permitted to explain.
No, that's one of the reason, my lord.
For payment of 1% handling charges.
Yes. That is one of the reason, my lord, given by the authority also. He discusses in this. He cannot give refund in cash. He says so.
Which has been settled by the Delhi High Court, Your Lordship. In Allen Diesel's, the Honorable High Court has held the refunds can be given in cash even if the DEPB scripts were utilized to pay the duty. So that is no longer res integra, Your Lordship.
So there was no demand from us, my lord. There was no assessment order from us. It is a reassessment under section 17 of the Customs Act, my lord. Reassessment is also an assessment. That's what the, my lord, that the judgment of the Honorable Apex Court, my lord, paragraph 37 says.
But the ITC decision, Your Lordship, was where a case where tax was paid on a duty was paid only by way of a mistake, not in the case of constitutional levy law. That's the distinction that I wanted to make, that where ITC that my learned friend is relying upon, along with Flock India or Priya Blue, all three decisions refer to cases which are contemplated as the illegal levy, not the unconstitutional levy which the Supreme Court in Mafatlal held. Supreme Court in Mafatlal held unconstitutional levy does not come under the purview of the Act itself. So therefore, the missionary provisions with respect to refund, Your Lordship, cannot be attracted with respect to an unconstitutional levy.
Well, after the this impugned order, Lord, the matter went back, a consequential order came to be passed by the authority, rejecting the refund application. White order dated 29th January 2020.
My Lord, I am pursuing the appellate remedy for that, Your Lordship, saying that the remand scope was very limited, only to verify. The adjudicating authority has gone beyond the scope of remand of the tribunal, Your Lordship.
Okay. Tell us one thing, as in department, those cases which were prior to 2017 or 15, where they have paid 1% handling charges, have you refunded to everyone?
No, my Lord, I don't think so, man.
Huh? Would not have. And this is a post.
My Lord, what happens is refund has to pass through two tests. One is limitation, one is an unjust enrichment. My Lord, in most of the cases, my Lord, the burden is passed on to the consumer, next customer. So, my Lord, in those cases, my Lord, most of the parties, my Lord, even they don't seek refund also, because they might have recovered that cost from the, my Lord, their customer. Here he contends that, my Lord, he has not passed on that burden to the, my Lord, his customer. That's why he's before the court. Because this being, my Lord, indirect, this thing levy, no, they go on passing the, my Lord, the burden of taxation to the, my Lord, ultimately it reaches the ultimate consumer. So most of the parties may not pass through this test of unjust enrichment, my Lord. So such an event, my Lord, many people don't claim the refund because they might have recovered that 1% handling charges, my Lord, from the next. They might have included it in their cost. That could be the, my Lord, in most of the cases.
Lordship, in fact, the appellate authority in the first round has already examined unjust enrichment and has held it in my favor, Your Lordship, which is a finding in the tribunal's order. Explicit finding in the tribunal's order, a factual finding saying that the original appellate authority's order holds the unjust enrichment issue in my favor, saying that I have not passed on the burden of the customs duty paid. In fact, the revenue was not on appeal before the tribunal on this issue, Your Lordship.
Now, one more, my lord, this has not been held as unconstitutional, as my lord,
Oh, no, no, no.
this levy has not been struck down as unconstitutional. Your Worship, my lord, operative portion of this judgment of the Wipro. We are therefore of the opinion that impugned amendment, namely proviso to so and so, while notification is unsustainable and bad in law as exists in the present form, and it has to be read down to mean that this clause would apply only when actual charges referred to in clause B are not ascertainable.
With great respect, Your Lordship, paragraph 31. Paragraph 31 explicitly states it would be addition of 1% of free on board value is thus in circumstance clearly arbitrary and irrational and would be violative of Article 14 of the Constitution. Explicit finding, Your Lordship.
Which is your judgment you are relying upon?
My lord, two judgments on this. One is a Priya Blue, my lord, I just handed over. Two. That ITC, my lord, I stress upon. Second judgment after third starts. Your Lordship may kindly turn to my lord, page number 17. Para, my lord, 43. As the order of self-assessment is nonetheless an assessment order passed under the Act, obviously it would be appealable by any person aggrieved thereby. The expression any person is of wider amplitude. The revenue as well as the assessee can also prefer an appeal agreed by an order of assessment. It is not only the order of assessment, reassessment, which is appealable, but the provisions of section 128 make appealable any decision or order under the Act, including that of a self-assessment. My lord, here it is a case of a self-assessment. The order of self-assessment is an order of assessment as per section 2.2. As such, it is appealable in case any person is aggrieved by it. There is a specific provision made in section 17 to pass a reasoned speaking order in the situation in a case on verification. Self-assessment is not found to be satisfactory. An order of reassessment has to be passed under section 17.4. Section 128 has not provided for an appeal against the speaking order, but against any order which is of wide amplitude. The reasoning employed by the High Court is that since there is no list, no speaking order is passed, as such an appeal would not lie, is not sustainable in law, is contrary to what has been held by this court in so and so. The provisions of section 27 cannot be invoked in the absence of amendment or modification having been made in the bill of entry on the basis of which self-assessment has been made. In other words, the order of self-assessment is required to be followed unless modified before the claim for refund is entertained under section 27. The refund proceedings are in the nature of execution for refunding amount. It is not assessment or reassessment proceedings at all. Apart from that, there are other conditions which are to be satisfied for claiming exemption as provided in the exemption notification. Existence of those exigencies is also to be proved, which cannot be adjudicated within the scope of provisions of refund. While processing a refund application, reassessment is not permitted, nor conditions of exemption can be adjudicated. Reassessment is permitted only under section 17(3), 4, and 5 of the amended provisions. Similar was the position prior to the amendment. It will virtually amount to an order of assessment or reassessment in case of so and so, while dealing with refund application is permitted to adjudicate upon the entire issue, which cannot be done in the ken of the refund provisions under section 27. In so and so, though the High Court interfered to direct the entertainment of refund application of the duty paid under mistake of law, however, it was observed that amendment to the original order of assessment is necessary as the relief for refund of claim is not available as held by this honorable court. This is the proposition.
Yes.
If I may be permitted to refer to the very same decision my learned friend has referred to, Your Lordship. Paragraph 8. The very same decision, Your Lordship.
It refers to Mafatla.
No, Your Lordship. Paragraph 8 of the very same decision. My lords have it. The starts on appellant had been paying.
Yes.
The appellant had been paying duty on paper cleared from its factory. The rate of duty of paper manufactured from conventional and unconventional raw material differed. The appellants availed exemption under notification so-and-so, dated so-and-so, as to the duty in respect of waste paper fresh broke. By notification number so-and-so, complete exemption was granted in respect of paper up to the specified quantitative limit manufactured from unconventional raw materials. Upon receipt of a letter dated so-and-so from the Superintendent of Central Excise, the appellant examined the matter and realized the mistake committed by it in availing the exemption under notification in respect of waste paper broke utilized in manufacture of paper cleared at nil rate of duty under notification so-and-so. From May 2001 onwards, the appellant stopped availing the exemption and started payment of duty on waste paper. The relevant period involved in these appeals was so-and-so. The appellant's assessments for this period were provisional, and these entries were finalized on 30/1/2003. The provisional assessment order was passed on 1/3/2002. The appellant had claimed that at the time of the final assessment order dated so-and-so, it was not aware of the notification so-and-so, and as such, no claim thereunder was made till that time, nor was any such claim so considered decided. The submission I'm trying to make, Your Lordship, this is a case where duty, excise duty in this case, was paid under a mistaken understanding of the exemption notification. Whereas in the present case, paragraph 31 in the case in Wipro explicitly states that the levy of 1% of FOB value is unconstitutional. It's violative of Article 14, and by a mechanism in the operative portion, it has read down, Your Lordship. One of the mechanisms to ensure that the congruity of a law is preserved is yes, sir.
Since when you have been paying these handling charges?
Lordship, during my instructions, Your Lordship, when the bills of entry were filed for this particular period, they were paid, Your Lordship.
No, from the earliest point of time.
Lordship, I don't have instructions, information with respect to
We
the.
want to know. But then why are you not claiming that also back? That's also without authority of law.
I am grateful, Your Lordship. I'll have to find out.
But now, very well. Let's assume for a moment you have been paying, let's assume hypothetically 1990.
Yes, sir.
So you will seek refund from 1990.
Lordship, the Mafatlal decision says I can go back only 3 years. Mafatlal Supreme Court says it becomes a civil suit or a writ petition, and the limitation prescribed under the Article 14 will apply, Your Lordship. It will not be a open-ended refund application for the petitioner at that point in time. In the case of
Mafatlal doesn't deal with where an assessment has been filed, assessment attained finality. It is only on a proposition of law, on an aspect where the matter had come to the High Court. The Supreme Court was considering it when in such an eventuality a petition is filed, what is the position of law? There is no dispute, or they cannot be contested if today for a moment you had not filed your assessment and you straight away went to the High Court saying that this levy which they are claiming could not have been claimed, and hence whatever I have deposited that should be refunded. Possibly we are with you. But what is happening is the assessment has come in between, and you had that point which you could have urged before the assessing authority, saying that such a levy is bad in view of the Supreme Court judgment. You don't pursue it. Now, maybe in retrospect, maybe possibly you have come to know about the judgment in Wipro that you made a claim for refund, which they rejected.
My Lord, if I could put it in this way, the Supreme Court itself created a dual system of refund claims. One is an unconstitutional levy subjected to a civil suit or a writ petition for claiming refund. Any mistaken payment or an illegal payment by mistaken understanding, wrongful interpretation, that will come under an illegal levy, which was covered under the provision. So which means that it goes through the...
You have paid it with your open eyes. Even during assessment, you don't take that point.
Your Lordship, reason is, in 2017, the notification which brought out that rule was amended. In 2017, the amendment happened, Your Lordship. So the assessee at that point, and my understanding is that till the amendment, he continued to pay, as he must have obtained legal opinion on whether the refund becomes claimable only from the date of amendment or because of the fact that the Supreme Court read down the provision, held it to be unconstitutional, it will date back to the dates of the bills of entry. Now, the ITC decision, Your Lordship, was rendered only in 2019, well before the refund claim being filed. Therefore, because the ITC judgment was only rendered in 2019, Your Lordship. And 2018, I had already filed my refund claim on the ground that there is the levy itself was held unconstitutional. The original argument of the department to reject it was only on the ground that 2017 amendment to the rule is prospective and not retrospective, where we have always submitted that the moment the Supreme Court renders a particular provision non-extant law, it dates back to the original levy itself. That's the distinction that I wanted to make, Your Lordship. Even the ITC decision was not concerning an unconstitutional levy. Therefore, Your Lordship, this will be a case where a refund claim was filed under Section 27 of the Customs Act for an unconstitutional levy. Whether it will continue to be subject matter of rigors of the self-assessment contemplated contemplated by the Honorable Supreme Court in the case of ITC, or will I be covered by the decision of the Constitutional Bench in the case of Mafatlal, which says that unconstitutional levy refunds do not fall within the purview of the Act itself. The moment I'm ousted from the Act, Your Lordship, the rigors of the assessment, self-assessment being made applicable to me will not arise as the submission that I want to make, Your Lordship. The primary is.
Your Lordship, can you, my Lord, observe this thing, contradiction in this? If he says that, my Lord, this is not a levy at all. This is not a levy under the provisions of the Customs Act. Now, my Lord, if this is not a levy under the provisions of the Customs Act, my Lord, he could not have invoked the provisions of the Customs Act to claim it back.
Come again?
If he claims that this levy is outside the provisions of the Customs Act, and it is hit by, my Lord, Article 265 and illegal and void, he could not have invoked my Lord, the provisions of the Customs Act to seek refund of that. See, once you make an application for seeking refund of a levy, that means that, my Lord, it was a levy, my Lord, which was according to his understanding, was in accordance with law. Now, something which is paid, my Lord, outside the provisions of law, my Lord, to seek the refund of it, my Lord, again, my Lord, resort to the same provisions of law and say that, my Lord, you return this by exercise of power under this, since it is not a part of the customs levy.
Yes.
He cannot contend both. This is, my Lord, the fallacy, my Lord, basically, my Lord, in the argument that at the same time, my Lord, you say that it is not a levy under the Customs Act, unconstitutional, outside the law, reverse the law. And at the same time, my Lord, he cannot resort the same provisions of law to seek a refund of it.
Lordship, it ultimately becomes a procedural aspect, Your Lordship. Section 27, the application becomes the procedure that I have applied. And my learned friend is absolutely right with respect to the.
He is arguing for you.
Yes.
Lordship, the primary argument is the monetary limit issue, which anyway the appeal is well below the monetary limit. Second, Your Lordship, if we have to get into the aspects of law, I wanted to rely on the decision of the Honorable Supreme Court in the case of Mafatlal. What my submission is that, Your Lordship, the application made is a procedural infraction, assuming it is a case where I should not have applied the application form under Section 27, but it's only a procedural defect. But the substantive law is the government cannot retain a any amount which has been held to be unconstitutional, Lordship. It will be unjust enrichment on the part of the government. The government cannot unjustly enrich itself based on a procedural infraction that the assessee has done.
My Lord, in the writ jurisdiction, my Lord, these arguments might have been available. Not in the appellate jurisdiction, my Lord, that's my humble submission.
And the submission with respect to ITC is taken for the first time, Your Lordship.
He could have very well filed a writ petition, my lord, challenging the order of rejection of a refund directly. Lordship, in the writ, my lord, proceedings, my lord, all these arguments could have been made available to him.
Is the assessment order on record?
Assessment order? No, my lord, the assessment
Then-
order is
Self-assessment.
self-assessment.
Bills of entry, Your Lordship. The moment I make an amendment to the bill of entry, it becomes an
Bills of
assessment order, Your Lordship. Under section 149 of the Customs Act, if I make an app,
You file your assessment and left it at that.
Yes.
And that assessment also refers to this 1%. No claim, nothing.
Nothing.
He did not seek sort of a disallowance or something like that.
My lord, what if he had a doubt about this? He could have said that I have a doubt that whether I am liable to pay or not. However, I am paying it under protest, subject to finalization of an assessment. If he is understanding what my learned friend is arguing now, that also he did not do. Very consciously, they have made a payment, got an order of assessment.
Okay. We will reserve it.
Lordship, if I may be permitted to make a short set of submissions, Your Lordship, in a written note.
When will you do it? Tomorrow morning?
Yes, Your Lordship, I will do that. I will submit it tomorrow morning, Your Lordship. A summary of all my submissions that I've made today, Your Lordship.
Do it tomorrow morning.
Obliged. I'm grateful.
Reserve counsel for the parties to file their brief
Then
note of
also-
submissions by tomorrow morning. That's all, ma'am. Just keep it.
I'm grateful, Your Lordships, for patient hearing.